Now calling the case of State of Lone Star versus Alex Hamilton, case number 2016-37. Announcement, please.
Good afternoon, my name is Austin. I'm here with the council of civil law.
Are you ready?
Your Honor, my name is Bashar Randolph, and I'm here with my co-counsel,
William Zaccarini.
we have the honor of representing the defendant, Will Hamilton, in this, or Alex Hamilton in this case. And we're ready to proceed to opening statements pursuant to some housekeeping matters and a motion of limiting one part.
Okay, then let's address the housekeeping matters before we proceed.
Yes, Your Honor. We came to a successful pre-trial conference with the government, and we agreed to the admissibility of Exhibit D in this case. And at this moment, we want to move to admit that exhibit.
Let's say the defendant, I would plan, what's the state?
We agree with
Yes, Your Honor. And we also asked your preference if we would be allowed to move freely about the well.
Upon seeking permission at that point in time, the answer is yes. You do not need to. I've given you permission, you can move freely, but do not just assume that you have permission to move.
Okay. I seek clarification. So,
Ask me if you, ask me to leave your seat, ask me to leave council table, and if I get that, if we grant that permission, you have the ability to do that. Otherwise, don't assume that you just can get up and start moving around without asking permission.
understood, Your Honor. And can we constructively read the jury charge prior to closing statements to the jury?
Absolutely.
And lastly, can we constructively publish the exhibits after they are admitted?
I'm not sure exactly what you mean by that.
Constructively publish to the jury. We don't have a screen.
I understand.
So can we constructively do that?
Yes, but explain exactly how they would be published, assuming that you had the technology needed.
Yes, Your Honor. We would just show the jury on the screen.
No, with each exhibit, because each exhibit is going to have potentially different characteristics. I want to know how we want to know how it's being presented to the jury.
Yes, we may give you a copy of the exhibit. And we also have a courtesy binder for you. If you would like, I can have my co-counsel bring you a binder, and it just has the case and the exhibits marked with a green tab.
Sure.
3 minutes.
Have you shown that binder to opposing counsel?
Okay.
As a matter of housekeeping from the court, you're under some specific time constraints, which you should already be aware of. We, as a courtesy, will provide you with a 3-minute warning. You will hear the words 3 minutes, meaning you have 3 minutes to complete whatever it is you were doing at that point in time. Understood?
Understood, Your Honor. At this time, the defense has no further housekeeping matters. We just have a motion of limine in one part.
Okay, what is that motion in limine? Is it in the binder?
No,
Okay.
I will be speaking to you about it.
Is it not written?
It's not written.
Okay, what's the motion?
Yes, Your Honor. This case is about a murder where our client, Alex Hamilton, is being accused of a murder. And we have a witness that will actually come forward named Liz Mulligan, who will confess to that murder. Now, Liz Mulligan had a prior deposition. And in that deposition, Liz Mulligan spoke that she only has 1 year left to live due to a cancer diagnosis. And we want to keep that testimony out and keep the prosecution from asking about that testimony because it's substantially more prejudiced than probative, and it's speculation. You see, the witness gave testimony that they only have a year left to live, but we have no information on, what kind of doctor, or if a doctor gave that information, and a doctor won't come forward as an expert and testify to this. And we believe that the government is actually going to have the jury infer that because Liz Mulligan only has a year left to live, that they have nothing to lose and that they're going to take the blame because they have nothing to lose.
Say the state.
We object to that. Ms. Mulligan, this is her personal knowledge of her own diagnosis that she was already comfortable to explain. This is extremely relevant to promote it as to why she is coming forward. And again, she would have personal knowledge. We would need a doctor to clarify that if she would know.
What I heard was 2 points. I heard one, that, which, by the way, I would agree with you on that. I don't know, I'll talk to my panel, but the other one, I'm more interested in the probative value outweighs the prejudicial effect outweighs the probative value. Address that.
Yes, sure. It would be extremely probative because it goes to her what matters to you moving forward. It also explains parts of her relationship with the defendant himself.
How would that outweigh the prejudicial degree?
Because it would go to her credibility. She's coming forward saying that she committed murder. So what would it affect a jury knowing that is since they're giving her a year back to them would be
What I'm going to do is I'm going to grant that motion. But I'm not telling you that I am ruling that it is inadmissible at this point in time. I'm just granting the motion in limine. I don't believe you need to be addressing it at the opening statement level approach before you want to put that specific into evidence, and we'll address this probative value versus the prejudicial effect at that point in time. Understood? Okay.
and the state also has housekeeping and information.
Okay. What is the motion? What is your motion?
First, we would like to limit the admission of Phil Hamilton's prior criminal history. 12 years ago, he was arrested for a cocaine charge, and 5 years ago, he had another charge he was confined to. And we would argue that under 401 relevance as well as his prejudice.
I'm trying to understand, is the defense you believe is going to offer an acquittal?
No, Your Honor, this is a prior criminal history. This is Hamilton, Alex Hamilton's brother. He is testifying to the events of the murder.
Okay, but I'm understanding, but the prior part, the second one, there was an acquittal?
Yes, Your Honor.
So you believe they would be offering a charge? There was an acquittal. I thought I just heard you say, maybe I'm misunderstanding what you said. I thought I heard you say that there was a charge, he was tried and he was acquitted. You believe that the defendants are going to try to use that charge? Because is that, I'm just asking that question.
Just criminal history in general, is the drug charge, any like mention of the going to.
Let me ask the question. Are you planning on using that?
No, Your Honor. There's the two charges that they're talking about. The 12 years ago, where Phil Hamilton pleaded guilty. We don't plan on getting into that. And the acquittal, we don't plan on getting into. But there is a current conviction.
I don't think we're addressing the current conviction right now. We're addressing the two that she mentioned. If she wants to bring up the current conviction, we can address that in a minute. I'll grant that motion in limine. Based upon it sounds like it's agreed upon.
Yes, Your Honor.
That there was another.
Yes, Your Honor. We would like to limit out any mention of Phil Hamilton's prior criminal competency. This was in 2004 and 2005, and that would be connected to the first charge that he received. And it was a period for 8 months. He has since been evaluated by a doctor, and he is now been deemed competent.
3 minutes.
And that would be under 404 and 403.
Your Honor, we don't object to that.
Then it's granted.
Yes, Your Honor.
Is there anything else?
Yes, Your Honor, for housekeeping, they want to ask if we may assume or when is this something constructively prescribed?
Yes.
And lastly, and we assume that all of this have been.
Have they?
Yes, Your Honor.
And yes.
That would be the rest.
All right. Does the state wish to make an opening statement?
Yes,
You may proceed.
permission to go really back around.
Yes, you can.
You please the court. Secrets don't sink. Good afternoon. My name is Alyssa Vaughn, and I, along with my co-counsel, Sydney Preston, proudly represent the state of Lone Star. I want you to close your eyes, and I want you to imagine Coach Hamilton, the defendant, struggling marriage. And then I want you to imagine him chasing two girls in secret, leading up to their relationship. Then I want you to imagine one of those girls coming forward to Alex, telling him that she wants to publicize their relationship. I want you to open your eyes. Because that story is exactly what you're going to hear about today in trial. You're going to hear how Peggy Schuyler, one of Alex's girlfriends, told him that she wanted to publicize that relationship. And she told Alex that she wanted to publicize that relationship, and he knew that it would affect his reputation, decided to take matters into his own hands. You're going to learn that on January 29th, 2016, Peggy Schuyler was murdered. You're going to hear exactly why Alex Hamilton should be charged for that murder. We're going to bring you Detective Jay Lawrence, the head detective in Peggy's case. He's going to get up here on the stand. He's going to tell you how we found Peggy's blood in Alex's apartment and on the boat he used to dump her body in the ocean. You're going to hear that Alex's fingerprints were on that boat. We're also going to hear from Phil Hamilton, Alex's sister. She's going to get up on the stand. She's going to tell you how on January 29th, her brother called her asking for help to get rid of Peggy Schuyler's body. We're going to hear how his determination to kill Peggy Schuyler still haunts Phil Hamilton to this day. I'm going to show you a check from Alex Hamilton for boat parts, including the chain and the anchor that he tied around Peggy to make sure she sank that night. I anticipate that the defense is going to bring you some witnesses too. I believe they're going to bring you Liz Mulligan. I anticipate that she's going to tell you she committed the murder instead. Ladies and gentlemen, we're going to show you a note from the defendant, Alex Hamilton, giving her the exact instructions to tell the story that he wanted to publicize. You're going to learn that she didn't come forward until after she received this note. We also anticipate that they're going to bring you Alex Hamilton. And we believe he's going to try to throw all the blame onto Liz Mulligan. Ladies and gentlemen, when you onto Liz Mulligan. And ladies and gentlemen, when you hear that Alex Hamilton had the means to kill Peggy Schuyler, fireplace tool, and when he threw her off that boat that night, when you hear that he had the motive to kill Peggy Schuyler because she was going to publicize their relationship and ruin his reputation that he held so dear, when you hear that he had the opportunity to kill her when he was alone in his apartment and when he was with his sister on that boat, you're going to find there's no other reasonable explanation besides holding Alex responsible for this murder. I want to acknowledge something. Today, as a state, we have the burden of proof. We have to prove beyond a reasonable doubt that Alex committed this murder. I anticipate the defense will get up here
and emphasize how heavy that burden is. Ladies and gentlemen, when you see forensic evidence that Peggy was murdered in his house, that Alex was on the boat that night, and when you see the note that Alex wrote Liz Mulligan telling her exactly what to say, we know that you'll find there is no other reasonable explanation. Alex Hamilton, you're gonna learn, tried to sink Peggy Schuyler. But secrets don't sink. You're going to find that the only conclusion that the evidence supports and that justice demands is that you find Alex Hamilton guilty. Thank you.
Your Honor, may I move freely about the
Wait till I ask. I was in the process of doing something. I will let you know when it's appropriate for you to make an opening statement. Okay?
Yes, sir.
Give me a second. I assume by your comment that you wish to make an opening statement,
Yes, Your Honor.
and you wish to make it now.
Yes, Your Honor.
The answer to your question is yes, you can move freely around as well. You may proceed.
The government's case isn't built on good police work. It's built on guesswork. Now, this case comes down to whether Alex Hamilton killed Peggy Schuyler, or whether you believe Alex Hamilton killed Peggy Schuyler. Alex Hamilton won't sit in front of you and confess to the crime, but somebody will. Liz Mulligan. She'll take that seat under oath and tell you that she killed Alex Hamilton. My name is Bashar Randolph, and I, along with my co-counsel, Will Taclerini, have the honor of representing the defendant, Alex Hamilton, in this case. And our client, Alex Hamilton, is charged with 2 counts of murder. Murder in the first degree and murder in the second degree. And those elements, the elements of those 2 charges, they'll be explained to you fully. But essential to those charges is that Alex Hamilton killed Peggy Schuyler. And it's the government that has the burden in this case, and it's a heavy burden. They have to prove beyond a reasonable doubt every single element of one of those charges for you to find Alex Hamilton guilty. They won't be able to do that. They won't be able to do that because you'll find reasonable doubt in the lack of evidence that the government presents. You see, this is a murder trial, and it's built on an investigation. And that investigation should be a good one. Good investigations, good murder investigations often include a body. The government, the police, they didn't find a body. Now, we're not contesting that Peggy Schuyler wasn't killed, that she's not dead. But a body helps confirm who the killer is. It helps confirm time of death, mode of death. If the person was shot or hit or drowned, it helps show who was the angle that the victim got hit. All these things help confirm who the killer is. But the government won't be able to bring that evidence forward today. A good investigation often includes a weapon. You'll find that the government is confused on how Peggy Schuyler even died, whether it's from getting hit by a fireplace tool or from drowning, they don't know. And they don't know because they're relying on guesswork, not police work. The evidence will show. A good investigation includes credible witnesses. Now, the government's star witness, Phil Hamilton, will come to learn has pled guilty to cocaine trafficking. And they're awaiting sentencing in jail. Uncomfortable place to be. They want to get out. So you'll find that they made a plea deal. They'll tell you they made a plea deal because they're awaiting sentencing with a 15-year minimum and a $500,000 fine. So they made a deal, and that deal includes that Phil Hamilton will come up and testify. And not only did they plead guilty to cocaine trafficking, you'll find that they were on cocaine as they witnessed the events. What a credible witness. They want you to rely on that testimony, but that's not good police work. It's guesswork. A good investigation often includes other suspects. Liz Mulligan will sit in front of you and confess to the crime. And you'll learn that the government didn't question her, they didn't investigate her, they didn't arrest her, and that she was never a suspect. That's not good police work. That's guesswork. Liz will come up and tell you what happened. She'll tell you that she was at Alex Hamilton's home, and that Peggy Schuyler came in unexpectedly. An argument ensued. Liz Mulligan feared for her life because Peggy Schuyler was reaching for a gun. And Liz did what she thought she needed to do to defend herself. And our client, Alex Hamilton, will tell you how he's an experienced criminal defense attorney. And how he did a lot of things wrong then. Things that he could have done better. But what he did not do is he did not kill Peggy Schuyler. So before you all go back to deliberate, my co-counsel will walk you through the verdict. He'll explain that the lack of evidence shows that Alex Hamilton is not guilty. Therefore, justice demands a verdict.
State wish to call the first witness.
Yes, Your Honor, so State calls Detective Day Lawrence to stand.
Sorry, could you say it out?
Yes, Your Honor, the state calls Detective Day Lawrence to stand. Your Honor, may I stand in the hall? Good afternoon, Detective. Would you mind introducing yourself?
Yes, my name is Detective Jay Lawrence.
And what do you do for work?
I'm a detective with the Homicide Division at HPD.
Have you always done this?
No, before becoming a detective, I served my country as a part of the military forces for several years.
And how long have you been a detective?
Almost a decade.
And what does your experience look like?
Well, I've been a homicide detective on numerous cases, and I've been a supervisory detective.
And how many investigations have you had?
A lot. I cannot count how many.
Absolutely. And can you tell us a little bit about why we're here today?
We are here today because I was the supervisory detective into the murder of Hippard.
And how did you become aware of that murder?
Well, first, it was a missing persons case. I learned that Peggy Schuyler was last seen on January 29th, 2016. So that is how the investigation began.
And can you tell us a little bit about Peggy Schuyler, what you learned?
Well, after our sister reported her missing, our first step was to go and learn about her through a search warrant of her apartment.
And what about descriptions, things like that? What do you know about that?
Of course, Peggy, through all the information that I have available to me, Peggy was about 5'6". She was 125 pounds, and I'm remembering her, she was 27 years old at the time she was missing.
At this time, Your Honor, the state would like to read in stipulation 3A, 3B, and 3C. The state and the defense agree that the jury may be informed of the following if the state or the defense request. A, Peggy Schuyler was 5 feet 6 inches tall, weighed approximately 125 pounds, was 27 years of age. Stipulation B, except for out-of-town trips, illnesses, and vacation, Peggy Schuyler has attended a plain Sunday night dinner with her family once every month for over 5 years. And C, Peggy Schuyler's sister, Eliza, reported Schuyler missing to the police department on January 31st, 2016, after Schuyler's co-employees notified the sister that Schuyler did not appear for work on January 30th, 2016, and the sister was unable to locate Peggy Schuyler at her apartment. So now going back to the apartment search, can you tell us about that?
Yes, it seemed like she had just stepped out, and so she would walk right back in at any moment. Her things were undisturbed. See, numerous personal items, clothing, toiletries. It's as if she had just went back.
And in this investigation, did you do analysis or anything like that?
Yes, at Peggy Schuyler's apartment, we were able to identify 3 sets of fingerprints.
What was the result of that?
We found fingerprints belonging to Peggy Schuyler herself, Peggy Schuyler's sister, when we reported her missing, as well as someone named Alex Hamilton.
Who is Alex?
The defendant.
Would you be able to put on court today?
Yes.
Can you do so by an article of clothing?
He is seated next to defense counsel wearing a black shirt.
Let the record reflect that Detective Dave Lawrence has identified the defendant, Alex Hamilton, by an article of clothing. And at this time, the state would like to read in stipulation 3B.
Objection.
No objection, Your Honor.
3 fingerprints of defendant Alex Hamilton's right hand were positively identified on Peggy Schuyler's coffee maker when Schuyler's apartment was searched. And what did you do with this information?
Well, once we identified Mr. Hamilton's, or the defendant's fingerprints on the coffee pot, my next step was to speak with him directly.
And when did you do this?
In the subsequent days.
And what result was this meeting?
Well, I met with Mr. Hamilton at his place of work, and he just stated lie after lie after lie.
When you say lie, what do you mean by that?
He denied knowing Peggy when his fingerprints were in her apartment. He denied having a relationship with her, and he made up this ludicrous theory that his fingerprint ended up on her coffee pot because he must have touched it when it was being sold at a store.
Did you do any other interviews?
I did. In addition to speaking with Mr. Hamilton, I also spoke with Peggy Schuyler's family, friends, coworkers. We were unable to find any information regarding how she went missing.
Did any of them know about it?
None of this was Alex. The relationship was a secret as far as I'm aware.
As a detective, what were your next steps in the investigation?
Well, at that point, the case was cold, and we needed a break. Thankfully, we did get one.
And what was that break?
I learned through the narcotics department that a individual named
Objection, hearsay.
she is saying that, this is information learned in the course of her investigation. There's,
Agreed. Tell me why it's not hearsay.
it is not hearsay because she has not said anything that another person has said. This is information, that she would have firsthand knowledge of as an investigator.
You're gonna have to do a little better than that, counsel. I'm not going to grant the objection yet, but would you please lay a bit more foundation before we, and then I will reassess the objection.
You said the case was cold. How did you learn? You said the case was cold. When did that change?
It changed, I believe, it was in early March, if I remember things correctly.
And how did it change?
It changed because I was able to speak with Phil.
And, what did you learn?
I learned that Mr. Hamilton,
Objection hearsay, Your Honor.
Yes.
This would not be used for the truth of the matter. This is the listener. We also, this would be information we learned. She's an investigator.
I'm gonna give you a short rub. I'm gonna overrule the objection at this point in time, but be careful, counsel. You're approaching you're looking over the abyss of hearsay here.
And how did this change your investigation?
we now know how Peggy Schuyler died.
And what were your next steps with this information?
My next step was to execute a search warrant on Alex Hamilton's home, his apartment or his home, as well as Phil Hamilton, his brother, his boat.
So let's break that up a little bit. Going to Alex Hamilton's home, what did you find?
Well, when I walked in, there were several things of note. We found physical evidence as well as biological evidence.
And let's go to the physical evidence. What did you find?
So regarding physical evidence, we found a note in the bedside table in the defendant's bedroom in his apartment in Harris County, Texas.
Your Honor, may I approach the witness and go to opposing counsel with remarks exhibit B? I am handing you exhibit B. Can you recognize this?
I do.
And without quite going into the details just yet, can you tell us what it is?
Yes, this is a receipt that I found, as I said, in the bedside table of the defendant's bedroom in his apartment in Harris County, Texas.
And is this a true and correct copy of the receipt that you found when you executed that search warrant?
Yes.
At this time, Your Honor, the state moves to enter its evidence exhibit B.
I would object on the hearsay, Your Honor.
Explain.
This is an out-of-court statement, and we know nothing about this, where this receipt came from, or anybody who printed this receipt.
Sustained.
And what other physical evidence? Oh, aside. Disregarding that, what other evidence?
In addition, we found fingerprints and blood at the scene.
And what was the result of that?
Well, we were able to identify, we found blood at the scene. I apologize, not the blood we were able to identify belonged to Peggy Schuyler. It was located near the baseboard in the living room, close to the fireplace, traditionally where some fireplace stokers or tools might be present.
At this time, the state would like to raise stipulation 3E.
Any objection?
No objection, Your Honor.
3 blood spots located by crime scene technicians on the living room wall and the baseboard of the defendant Alex Hamilton's residence were tested and determined through DNA analysis to be identified as the blood of Peggy Schuyler. And what else in this living room, if anything, did you notice?
I also noticed that despite the presence of any fireplace stokers or tools, it was clear the fireplace itself had been used. There was ash and wood logs, so I knew that somehow it had been used.
And so after you did this search warrant, you found this DNA evidence with evidence of your search, what did you do next?
As I said, we were also executing a search warrant of Phil Hamilton's boat.
And what did you find in that search warrant?
In that search warrant, we identified both blood evidence as well as fingerprint evidence.
And what was the result of the analysis on those?
Well, a fingerprint was found on a flashlight, which was located in the console of the boat. And that fingerprint belonged to the defendant. We also found, as I said, blood evidence, and the blood was identified as belonging to Peggy Schuyler, and that was out on the deck.
At this time, the state would like to read its portion of the report.
No objections, Your Honor.
Proceed.
3 blood spots located by crime scene technicians in a space on the deck of the boat owned by Phil Hamilton were tested through DNA analysis and were identified as the blood of Peggy Schuyler. G, 2 Latin fingerprints were located on the lens of the flashlight located in the compartment of the console of Phil Hamilton's boat. An expert fingerprint examiner has positively identified the prints as coming from the index and middle finger on the left hand of the defendant Alex Hamilton. And at this time in your investigation, did you all have a body?
Yeah.
Why not?
I've come to the conclusion that the body sank to the bottom of the ocean.
Objection, speculation.
Wait,
Is that our negative?
the objection was late, so it's over.
Yes, Your Honor.
So now, Detective, from the conclusion of your investigation, did it result in any arrest?
Yes,
Who did you arrest?
Mr. Hamilton, the defendant, Mr. Alex Hamilton.
Assets.
Cross-examine.
Yes, Your Honor. May I proceed? May I move freely on the law? Detective Lawrence, you've worked many homicide cases before, correct?
Yes,
You've worked at HPD for 14 years,
that sounds right.
worked on over 35 homicide cases.
Yes,
You would agree with me to keep thorough on your investigation,
I would.
to gather evidence,
Yes,
because evidence is important.
absolutely.
Your Honor, permission to approach the court this time for demonstration. Now, I'm gonna write here important evidence. You would agree with me that a body is important.
In some in investigations, absolutely.
A weapon is important.
Sometimes.
Interviewing other suspects is important.
Yes.
Camera footage is important.
It can be.
GPS data is important.
Can be.
Now, in this case, you don't have a body.
Unfortunately, He was able to dispose of it.
You don't have a weapon?
Unfortunately, he was able to dispose of it.
You never interviewed any other suspects?
Well, we interviewed many people through the course of our of our investigation. I'm unaware whether or not they were identified as suspects or not.
You didn't gather any camera footage?
No, but many times it's not available, unfortunately.
You don't have any GPS data?
We don't.
Now, I'd like to preserve this as defense demonstrative 1, Your Honor.
Identify it as such.
In this case, you never went to the marina and looked for other witnesses, did you?
Witnesses at the marina? No, we did not.
You never looked for ramp logs at the marina?
Ramp logs?
You never looked to see what boats went in and out of the ramp?
No, I didn't.
Never looked to see what boats went in and out of the dock?
I did not.
You looked for camera footage at the marina?
I don't believe we were able to find any.
Now, in this case, you know that Mr. Hamilton has a second girlfriend, correct?
Aware that he has many women in his life.
You know he's dating Liz Mulligan?
Yes.
You never interviewed her.
No, we had no reason to believe Liz Mulligan was involved in the murder till the first trial.
You never even questioned her.
We didn't know the relationship was a secret, and Mr. Hamilton didn't tell us, and Phil Hamilton didn't tell us. We would never have known to interview.
Now, I want to go to the fingerprints that you found on Bill Hamilton's bill. The fingerprints you found on the flashlight, you're not able to gather a date on those, are you?
Not to my knowledge.
You're not able to tell how long they've been there
To my knowledge.
or when they were there?
When they were placed there, no, we were not able to do that.
I have no further questions, Your Honor.
Redirect.
Yes, Your Honor. Detective, describe consistencies in every investigation you do.
Consistencies? Right. Well, we look for physical evidence, we look for biological evidence, we interview people that know the victim or know the potential victim or murder victim in this case, or missing person.
Did you do those things in this case?
Absolutely clear. I've discussed how each of those things was done.
Now, looking at this demonstrative, does every investigation have a goal?
Fortunately, no. And a lot of times, murder was disposed of a body. Purely because if every investigation relied on the presence of a body, then murderers, it's very good for them to dispose of it, so they wouldn't be brought in and charged for a crime.
And what about a weapon? Does every investigation have a weapon?
No, unfortunately, if the defendant got rid of the weapon, we would
Objection,
not be able to
speculation,
find
Your Honor.
Overruled.
And does every investigation have camera footage?
No, this it's 2016 right now. We don't have cameras on every street, in every marina. Maybe in the future we'll be able to have access to more camera footage, but right now it's just not something available this decade.
Does every investigation have GPS data?
No, I think I have my TomTom in my car right now. GPS is a pretty new invention.
And the boat ramps, does every boat ramp have boat logs?
I mean, I'm just a humble detective, so I don't have personal knowledge of whether every single marina has a boat ramp or boat log.
And going to that last one, the other suspects, When did you become aware of Liz Mulligan?
I became of Liz Mulligan in the first trial where she testified.
Does this change the conclusion of your investigation?
No.
No further questions.
Recross,
No, Your Honor.
can this witness be excused?
Yes, Your Honor.
Excused. Do you have another witness?
Yes, sir.
Call your next witness, please.
At this time, the prosecution calls Jill Hamilton to stand. May I proceed, Your Honor? Good afternoon, Ms. Hamilton. Could you please introduce yourself to the court?
Hi, my name is Phil Hamilton.
And do you know why we're here today?
Yes, unfortunately, we're here today to speak about events that happened on January 29th between myself and my brother.
Who is your brother?
My brother is Alex Hamilton.
Could you identify him in the courtroom today?
Yes, he's sitting right here in the black button-down shirt.
Let the record reflect that the witness has identified the defendant as Alex Hamilton.
Door plug.
So now let's talk about what happened that night. Could you tell us how January 29th, 2016 started?
Yes, so I was at my house and then I received a phone call from my brother around 11:30.
So how did that proceed for you?
Well, he seemed a little frantic and was asking me to come over immediately. So, of course, I dropped everything and I went to his house.
What happened when you walked into his house?
Well, he opened the door and showed me into the living room, and I saw what appeared to be a rug rolled up and secured by some heavy twine to stick from a line.
Did your brother tell you what that was?
Yes, he told me that it was one of his girlfriends, Becky Schuyler, and that he had killed her.
Did he tell you why he killed her?
It was something about being anxious.
Objection to hearsay.
Your Honor,
Pause.
this is an admission by party opponent. So I'll ask you again, Ms. Hamilton. Did he tell you why he killed Peggy Schuyler?
Yes, he said he was nervous that she would be going forward with their affair.
And what happened after he told you?
Well, I was surprised because I knew that my brother was married. I was unaware of him being with anybody else. But after that, he did ask me to help him in disposing of the body.
And how did you respond to that?
Well, I mean, I was going to respond to that. I was confused, shocked, but again, he's my brother and he has helped me in the past. So I said I would assist him.
I just want to back up for a second. So, told you that he killed her. Did he tell you how he killed her?
He said that he had hit her with a fireplace stoker.
So now going back to he helped you. What was the first thing you guys did together?
Well, we picked up the rug, pretty heavy, and we carried it to my car and put it in the trunk.
And once you put the body in the trunk, what did you do?
Well, he wanted me to dispose of the body in the Gulf of Mexico, so we began driving to the marina where my boat is located.
Once you arrive, what do you do?
So we took the rug out of the trunk of my car. I mean, it was pitch black, it was after midnight, there's nobody around, so we took the rug to my boat.
I want to just clarify something. Could you have picked up this body by yourself?
No, I mean, I'm a fairly small sized woman, but on top of that, it's dead weight and the rug is really large and bulky. There's no way that I could pick that up by myself and put it in a car or load it on a boat.
So once you're on the boat, what happens?
So he asked me to drive 12 miles out, and I did just that.
What happens when you get 12 miles out?
Well, I stopped the boat. I informed him that we were about 12 miles out and proceeded to take my anchor from my boat. He unlatched the chain from the boat that's attached to the anchor, wraps the chain around the rug, and then gets ready to throw it over the boat.
What happened? What are you thinking during this time?
The whole thing was insane. So I'm just, again, in shock, just kind of ill. And then all of a sudden, I heard a very
Objection
distinctive,
to hearsay.
Sorry. I didn't understand.
Yes, Your Honor, the witness is about to testify to what they heard, and I'm objecting to hearsay.
Okay.
Can I explain?
I hear it from.
Well, the witness is about to testify that they heard a groan from the body, and I understand the abstraction of what they heard being a groan, but it's a statement in the sense that it expresses that that person was not dead, alive, and that they were feeling something. So, because it's going to the truth that that groan actually occurred, I'm objecting to hearsay.
I'll ask you again, Ms. Conley. Can you tell us more about what happened?
yes, so I heard a very distinct groan. And in that moment, I looked at my brother and said, "You should take her to the hospital. She may still be alive and you won't be guilty of anything."
How did your brother respond to that?
He did not seem to care. All he said was, "Well, she'll be dead soon enough," and then threw her in.
Then what happened?
I mean, I was sick to my stomach. I threw up over the side of the boat. And then he just grabbed a flashlight to make sure the body drowned. And I had just never seen my brother behave so heartlessly.
How did it feel to see your brother act?
Objection to relevance.
Sustained.
So what happens after you watch your brother dump his body into the ocean?
Well, I mean, that was pretty much it. We both sat back down, they drove us back to the marina. We didn't say anything to each other, and I took him home.
I want to make something clear. So had your brother ever been on your boat before?
Yes, he was on my boat about 6 months before that as well.
Had he ever been on the boat without you?
No, not to my knowledge.
So did you know if Peggy had ever been on the boat?
Peggy certainly had never been on my boat before.
So after you arrive home, what's the next interaction you have with your brother?
Well, I received a check in the mail on February 3rd from him.
Would you recognize that check if I showed it to you?
I would.
Permission to approach, Your Honor. Let the record, thank you. Let the record reflect I'm tendering Exhibit C to opposing counsel. Now handing you Exhibit C. Do you recognize it?
Yes, I do.
Does it appear to be altered in any way?
It is.
Then how do you recognize this?
This is the check that I received from my brother on February 3rd.
Is it a true and correct copy of that check?
It is.
Your Honor, at this time, we offer Exhibit C into evidence.
Objection to hearsay.
May I see the? What's the hearsay, basis for hearsay objection?
Is all the statements on the check.
So, Ms. Hamilton, who is this check signed by?
My brother, Alex Hamilton.
So, Your Honor, at this time, can we have a ruling on whether this is admitted?
Yes, it's admitted. Overruled his objection to it.
Yes, Your Honor. I just wanted to clarify for the record. So, you said it's signed by Alex Hamilton, and what's the date on this check?
February 2nd, 2016.
How long after the murder is that date?
Only a few days later.
And what is could you read out what the floor section says on that check?
Yes, it says boat parts.
And what boat parts could he possibly be referring to?
He could only be referring to my anchor and the chain.
Did you ever cash this check?
I did not.
Why not?
Honestly, I was nervous that this may come back to me, and I felt that this might be a good piece of evidence to prove my innocence.
So after receiving this check, when's the next time you talked to your brother?
He came to visit me in jail in March.
And how did that interaction go?
Well, he had offered to represent me in my charge, and I told him that was unnecessary. I was working it out on my own, and I informed him that I had told the police about what he had done.
How did he react to hearing that?
He seemed shocked. He didn't say anything at all to me, though. He just got up and he.
Do you feel bad about turning in your brother?
And yeah, he's my brother, but he did something wrong.
Your Honor, at this time, may we publish Exhibit C to the jury instruction? And at this time, I pass the witness.
Cross-examination.
Yes, Your Honor. May I move freely about the law?
Ms. Hamilton, you currently reside in jail.
That's correct.
And that's because
That's correct.
so because you're in jail, you can't see your family.
That is also correct.
You can't see your friends when you want.
That's correct.
You have to eat when someone tells you it's time to eat.
Objection on relevance.
That's correct.
You have to use the bathroom in front of people when you're in jail.
Tell me yes.
Yeah.
Sure. Yes.
Took a plea deal.
I have not taken a plea deal as of yet.
You agreed. You came to an agreement with the government, didn't you?
I have not at this time. I guess in regards to a plea deal, nothing has been agreed to. But I have been informed that if I testify truthfully today, that will be told to my sentencing judge.
That's a deal.
There has been no specific terms laid out, so that is not a deal.
I want to be very clear for the jury. You agreed to testify, so a good word can be put in with the sentencing judge, yes or no?
I did agree to testify so that the sentencing judge knew I told the truth today.
And in your case, you're facing 15 years of prison minimum,
That is correct.
$500,000.
That's correct.
So I want to take us back to January 29th. You agreed to help your brother.
I did. He's my brother.
You agreed to just help him remove a dead body
Yes, he's my brother.
with nothing in it for you. You just agreed to that. So you said your brother called you and you put down everything you were doing to go help your brother.
Yes, that's what I
That includes the cocaine you were smoking.
did. I did smoke cocaine about an hour previously to that, but I was not at the time.
So you smoked cocaine an hour previously, and so you were high when you went to help your brother.
Yes, but you would sober up quickly too if your brother asked you to dispose of a dead body.
So you were high when you were helping your brother, and you went to his house to help him.
I did go to his house to help him.
And you said on direct while you were helping him, your brother told you some things.
Yes.
Your brother allegedly told you that he killed Becky.
My brother did tell me he killed Becky.
Allegedly told you why he killed Becky.
My brother did tell me why he killed Becky.
And investigator Lawrence came to speak with you about that.
Yes, after I was born into.
This was after that or before that?
Could you please clarify what you mean?
Detective Lawrence came to speak with you in March. But you didn't confess until, I mean, I'm sorry, Detective Lawrence came to speak with you in March, correct? And when Detective Lawrence came and spoke with you, you didn't tell him that Alex killed Peggy? Your testimony today is the first time Detective Lawrence came to speak with you. You told him that Alex killed Peggy. So, yeah. Your Honor, so your testimony today is that you told Detective Lawrence the first time he spoke with you that Alex killed Peggy.
I think that's what happened, but you can certainly refresh my memory of this.
So you don't recall?
I'm fairly certain that is what happened, but again, you can refresh my memory of this.
Did your deposition help to refresh your memory? Does the record reflect that I'm approaching the witness with their deposition? And I'm referring to page 16. We don't have any line numbers. I'll give you a chance to read this page about the first interaction you had with Detective Lawrence.
There's nothing on this section about speaking of it.
This is about I'll give you a chance to read it. Maybe I'll give you the full so you can have the context. So here's your full deposition. I'll help you refresh your memory. So the first time you spoke with Detective, you didn't tell him that Alex killed Peggy.
Doesn't say that on the testimony.
Right, because you didn't tell him that.
It just does not say that on my testimony.
You didn't tell him why Alex killed Peggy.
Again, it does not say that on this testimony.
Right, because you didn't tell him. Well, you did tell him after you got a plea deal the second time, right?
I would say that is not in line with the testimony.
Your Honor, may I read from the deposition? On page 16, it says, when I first talked to the detective, I could not give the detective.
Are you doing it to refresh her recollection or our evidence? Because I don't need to hear that. If you put it into evidence some way with this witness, please do so.
Your Honor, I'm using it to impeach.
Shot.
So have you ever testified differently that you've talked to the extent of 2 times?
I mean, I apologize if I'm misremembering, but I don't see anything here that says I spoke to the detective a second time.
So I just need an answer for the jury. You have testified differently?
All that my testimony says is that I spoke with the detective.
Well, I'll read it. It says, when I first talked to the detective, I could not give the detective an exact date.
I overrule that.
That is what that says.
Now, again, so when you first talked to detective, you couldn't give exact dates.
That is correct. I could not give an exact date.
You didn't tell him that Alex killed Peggy.
All I have in there is that I could not give an exact date.
Okay, so you had this deposition after you took a plea deal.
I believe that's correct.
And after you took that plea deal, then you told the government that Alex killed Peggy.
That is when I told the government. Correct.
That's when you said in your deposition that Alex killed Peggy.
Again, sure, that's correct.
That's when you told the government why Alex killed Peggy. That's when you told the government that you allegedly heard a groan from Peggy.
I did hear a groan from Peggy, and that is correct.
And that was all after you took the plea deal.
Again, no plea deal has been taken at this time.
That is when you accepted a deal to testify so you could get a good word in, put in with your sentencing judge. Yes or no?
That is correct.
Thank you. That's the
Redirect.
Ms. Hamilton, things got a little messy during the first couple of questions. So I just want to clarify what you were trying to say. When you talked to detectives, what did you tell them?
Well, I told them that my brother had killed Peggy's father.
The first time that you talked to them, did you leave out any information?
I just could not remember the exact date at that time.
They don't have possibilities.
Yes, Your Honor.
Awesome.
Yes, Your Honor. So your testimony today is the first time you talked to detectives, you told them that Alex killed Peggy.
Objection or abstinence.
Back up in. Correct.
That is what I'm saying today.
And you took a deposition in this case. And you were told to include all relevant information in that deposition.
I suppose so, yes.
Your Honor, let the record reflect I'm approaching the witness with their deposition. That's your deposition?
Yes, this is my deposition.
And this is what you say you were told to include all relevant information? And nowhere in there it says that you told the detective that Alex killed Peggy.
Correct. I don't think it says anywhere in here when I told the detective I killed Peggy.
Because you did.
Unfortunately, I think that's improper under the rules that we set up prior to the, one Trump.
Yes, sir.
When we did it.
At this time, the witness may say.
Anything else? From the defendant at this time, before we take a brief break.
Yes, Your Honor, the defense would like to be heard on a judgment of matter of acquittal. Now, first, may I proceed, Your Honor?
You may proceed.
Today, the government has failed to provide a venue in the correct state of Lone Star in Harris County. Moreover, taking the evidence in light most favorable party of the prosecution, no reasonable jury would be able to correctly make a decision that Alexander Hamilton committed murder and killed Peggy Schuyler. At that point, we would like to move for a judgment as a matter of
On what, I'm gonna tell you, just as the judge, what I just heard, and we're outside the presence of the jury, or does the jury assistant in all this?
this is outside of the presence of the jury, Your Honor.
What I think I heard was a witness, whether the jury wants to believe that or not, saying that they heard your client say that he killed her. That did it, is that what I heard?
Yes, Your Honor.
So are you asking the three of us to disregard that and make the determination from as to the factual inability of a jury to accept that? Are you, I mean, I thought that's what I heard, that there was testimony that he admitted to killing.
Yes, Your Honor, and this witness came on the stand and told you they were back high on cocaine.
Okay, well, then what you're asking this court to do is to make a factual determination that that individual is not credible. Is that right?
Yes, Your Honor.
Overruled. Why don't we take a 10-minute break?
Sorry.
Right.
Can't do that.
I was like, another.
Yeah, they should have addressed that. Are you?
So I don't know. I'm at least more, so I just.
They don't, because they have extra.
He's doing closing.
He is like, yeah, he would probably.
I mean, I just made.
Talking about their.
It really depends, like yesterday, like she was charged at 36.
Let's go the other way.
Yeah, I just wanted to watch it as much as possible, but I was just curious. I wanted to see this closing if I can't see it.
My fault.
Yeah. Well, the closing is definitely not gonna be.
Yeah, so I need to.
Yeah, because
Okay.
they have about, they have to present their case.
Okay.
Yeah. So,
I was just curious. Thank you very much.
yep.
Yeah, it's too much. He got bogged down. What he should have done, he should have definitely testifying to debate, yes or no.
And instead of like, doing like the whole,
And her saying maybe it's like, no, answer, like non-responsive judge. It's a yes, no question. I need you to answer yes or no.
That's true.
He needs to like control the opposing counsel's witness.
But he did challenge her
He-
credibility a
yeah.
lot. I mean,
And
didn't
he-
damage her credibility.
Right, but he just wasted too much time. Just fighting.
But I think he accomplished
he-
what he
yeah, he
needed to
did.
do.
Yeah.
That's
but-
why that's why it didn't matter if you were objecting to
Yeah.
all the questions, because the entire strategy and
Yeah.
you can start was to.
Please, they're at 43 minutes now.
Much more.
You have 43 minutes left to do
I
the
got-
whole thing.
I got 44:30
44, yeah, so they're at 44:30.
for the whole case in chief, because he
Yeah.
used 10 minutes on the cross.
Yeah,
Oh,
yeah, no, it was like way too long, and just that one question.
Yeah.
Oh
he-
shit, we're recording.
Oh, well, no, I think it's just broadcasting. Back to the room. It's 9:27, last 51.
We have two different times going on.
Yeah.
So, I mean, I understand it.
It's the live stream.
But they want you.
Do you want to talk up there?
Yeah.
really,
Okay. She is. But this was really good. One that was getting crossed. I thought she was good.
I think she's legitimately forgot. She ate whatever she did. So some judges will be. Sometimes,
You forget something.
yes. This is about your witness preparation.
See. So, because in mock trial, we had our witnesses. So the mock trial had our witnesses were graded just as witnesses. See.
Just want to talk about our friends again.
Good. How are you?
Solid, chilling.
Are you a witness?
Yeah, I'm gonna be up.
Kaylee and Abby did not break to finals.
Dang, what? You said something, never mind. You're not studying for torts? You wanted to come on a bailiff?
Well, I'm a 1L rep, so.
They did really
Oh, you have to.
Yeah, I'm not here.
That's how
by
Ramon gets you.
choice.
He makes you think like, nope, nothing important, and the next thing you know, it's like, well, you actually got to be here this weekend.
Yes, I'm doing 2 this weekend. I mean, I can still liar. Online and stuff on here.
Yeah.
So I'm doing 2 this weekend, so like hopefully can like not be mandatory for everyone.
Oh, that's pretty
You
smart.
don't need to do 6 at all. So you can pick however many.
You said go to 6 competitions and all?
No,
Or?
6 shifts in all.
Got you. How
So
long does
I-
the shift last?
1 round.
Oh, that's super chill then.
Yeah.
Okay. Yeah,
So like
it's
I could have did the whole weekend and did 5 shifts.
Oh, that's why Sarah was here yesterday too, because I was confused. I was like, I don't think they would willingly, give up the weekend before torts.
No, I was here because I did 1 shift on Friday, the morning shift, then I went to study towards. And I wasn't here at all yesterday, then I'm doing 1 shift today, so that's 2. So I have 4 more throughout the 5 competitions.
It'll be chill.
Yes, probably do like 2 per competition.
Yeah, I think that's a good way.
And then let everyone
Sorry about
else
that.
know.
Go on from there. But yeah,
Your mom's watching too.
I think we're doing good so far.
Yes.
I think I was doing good. I'll have like less time, but
Yeah.
still good.
Yeah, makes sense.
I think I'll be
I
good.
got you. I'll come catch up with you after.
I
They better.
I think it's absurd.
They can construct it. I was gonna say. But that means that you get an opportunity to redraw. Yeah, you gotta throw in. Also, because of the judge's ruling, if we're gonna publish an exhibit, I think he made a ruling. You can like say how you use exhibit. Yeah. confused about. That's, yeah, I think he's just like saying how. I didn't.
We got 7 people watching, guys.
Really? On the live stream?
Yeah.
Oh. All 7 of them are Anthony Williams.
Judges will be back.
Yeah, that's what I need here. Going to. Which then go into this because it was the same. This is yours, but I'm just saying the reason we didn't go into this was a state. Yeah.
So I hate my hands. But that's okay.
This guy was about to advocate with no chopstick.
I know.
That's
Can you imagine?
actually ridiculous.
You bring it with you every.
Oh.
It's probably better than, it probably should have.
That's what I was thinking too.
What was the scent of the flavor of your chopstick?
Tingle mint. It does make you tingle.
Tingle.
It's like stuck in. Oh no. I was like, sipping up. I'm scared. I was like, I'm gonna be here the whole while.
Question.
Apologize for being so,
Yeah, I
I
appreciate
was questioning you. I really get into it and stuff like that, but I didn't mean to.
We're gonna take a bit. Judge is running out of ink on his pen, so we're having to find another pen.
I'm trying to sit, bro. You have any questions, sit, bro?
I've only been teaching here since 2002, but I can't get into a law school.
Okay.
I know.
I have another one if you'd like.
Like, I don't know, like, the question, it was like, oh,
I was saying, so what I was gonna suggest is, it's like, what's now? We have review sessions next week.
I'm not worried about nothing else right now.
Yeah,
Like, I think so. Next, so
Right.
I'm gonna be all this.
I remember my perspective, I'm like, I was a little scared when I submitted it, so I just wanted to, give the heads up. It'll make more sense.
Like, I wasn't scared because
Yeah.
I have to sit there and figure out which rule to use. Like, once I know which rule to use, I am easily able to answer the question.
I totally understand,
So
yeah.
it's like, I know how to say everything else once I know.
Okay, got you, yeah,
So like, the problem is.
Yeah.
Obviously.
I should not even. Yeah.
Teaching the
You're
faster.
learning.
I'm
There's the
trying to-
circle. That is a clock and line. There's
Just
two.
two. Right, reflect my grade.
I lied.
Yes.
44.
You
use 26.
get 25 o'clock.
I was a little bit, yeah, I was like, wait, that's a little scary.
I was like, wait,
But
this
it's like,
sounds
makes
wrong.
sense.
Cause I was like,
Yeah, you
Oh,
were, I
God.
was like, wait, that doesn't.
That sounds good as a timer.
You guys have 44 things left.
absolutely.
I was, oh, okay. You want class to wait?
Yeah, that's how time.
That's true. Well, I'm a fast walker.
I mean, nobody can see it besides the projector, which I guess is the reason, you know what I'm saying?
I don't know.
It's just a digital clock.
Oh,
There's no reason why.
I'm trying to make notes that thinking that it's wrong. Because that's one reason why I want to- yeah.
You excited to describe our relationship?
Can't wait for cross.
Things don't explain. Give me one. I have I have offices in those. And I can't get in there because I'm here.
Yeah, does anybody, do you need?
Yeah, I'll show you. What I'm.
They'll bring me one.
Okay.
But I mean, I don't need to waste his effort to go out there to get it. So.
Yeah.
I don't care. Well, never mind. I should, I can't text him and say, don't bother. I found one, so. This is probably making me through, but I don't want to get 2/3 of the way through and have to stop everything, so. Defense, like.
Yes, Your Honor, the defense would like to call Liz Mulligan to the stand.
Say,
May I move freely about the will, Your Honor?
yes.
Good afternoon. Could you please introduce yourself to this jury?
Yes, my name is Liz Mulligan.
Ms. Mulligan, what is your relationship to this case?
Yeah, I was called into this case because I feel like I play a big role in it.
Do you know the defendant in this case?
I do know the defendant in this case.
How do you know the defendant?
We were in a serious relationship from 2015 to 2016 for about 9 months, and I carry his child.
Now, I want to take you back to January 29th, 2016. Do you remember that?
I do remember that evening.
Where were you?
I was in Alex Hamilton's home.
Why were you there?
Well, I was going to see him and I had a spare key as well as the code for the burglar alarm.
Now the spare key, was that to get to his house?
That was.
Now this burglar alarm code, did you ever use it?
I didn't use it.
Do you remember that?
I don't.
Why don't you remember that?
It was a long time ago and obviously times have been stressful since then.
Now, did anything happen when you were at Mr. Hamilton's home?
Yes, it did.
What happened?
Yeah, as I was waiting in his home, Peggy Schuyler walked in.
When Peggy Schuyler walked in, did anything happen after that?
Yes, we got into a little bit of a confrontation, just arguing as we both had a lot of love for Alex Hamilton.
As you were arguing, how did this unfold?
Yes, she started yelling. There was a lot of screaming going around. Tensions got very high.
Tensions rised. Did anything happen?
Yes, she began to reach into her purse for what I had believed to be a gun.
When she reached in for her purse, what did you do?
I just wanted to defend myself, so I grabbed the nearest tool to me, which was a fireplace tool, and I struck her across the head with it.
You struck her. How did she react?
She fell to the ground lifeless.
After she fell to the ground, what was your next step?
I wanted to call Alex.
Did you?
I did call Alex.
What did you say to Alex?
I detailed what had just occurred, and he told me that he would be straight home. He did.
How long after that call did it take her to get home?
Approximately 20 minutes.
Now, once Mr. Hamilton arrived home, what happened?
Yes, after he arrived home, he told me to keep quiet and to go home myself, not speak to us.
Did you go home?
I went.
And once you went home, what did you do?
Well, I took a shower and just tried to relax, and then I started calling Alex Hamilton.
Were you now after you went home? Did you ever see what happened after that?
I did not see what happened after.
Since January 29th, 2016, have you been in contact with Alex since?
Yes, I have. I received a letter from him in April of 2016, which told me to tell the truth to the police.
Did you say that letter?
I did say that letter.
I'm showing opposing counsel what's been pre-marked in a minute of this exhibit D. May I approach the witness, Your Honor?
Is it in here?
Yes, Your Honor. I'll send 2 more copies. May I approach the witness?
Sure.
Now, what is this?
This is the letter that he sent me in April of 2016.
Your Honor, at this time, I would like to publish this letter to the jury.
Yes.
In this letter,
It's already been pre-admitted, correct?
yes, Your Honor. Can you explain this letter to the jury?
Yes, I can. In this letter, Alex detailed to me that I needed to come forward the truth of what occurred that night.
Is what's in this letter the truth?
Objection leading.
Ask the question again.
Is what's in this letter the truth?
Yes, the events that transpired were the truth.
Now, what does the last line say? All the way at the bottom.
You must help me. This will have, or my apologies. The very last line says, love Alex.
Now, did you tell the truth today?
I did.
Did you ever talk to the police?
I did. I came forward after this.
When was that?
That was in April.
Were you ever questioned by police? Did they ever interview you?
They did not.
Were you ever a suspect?
I was never a suspect.
Enough of the questions. You're now past this.
Cross-examination?
Good afternoon, Ms. Mulligan. I want to talk a little bit more about your relationship with Alex. So you said you were in a serious relationship, right?
That's correct.
Been in it for 9 months.
Yes.
You were even pregnant with his child at the time of this murder.
Yes.
So it's fair to say you care about Alex, right?
Sure. Yeah.
And he promised you that after this trial to continue your relationship, right? You want that, right?
I haven't given it too much thought.
But you're aware of the possibility, right?
Yes.
You also work with Alex, right?
Objection, relevance, Your Honor.
I respond, Your Honor?
Yes.
This goes to the witness's relationship with Alex and her bias for why she would want to come forward in support for Alex. I'll ask you again, Ms. Milligan. You worked for Alex, right?
Correct.
And you got that job in May, correct? After you came forward for Alex, right? So if Alex is convicted, you could lose your job, right?
Not sure.
Well, you work for his firm, right? So if that lawyer from the firm goes to jail, why not work at that firm anymore, right?
It's a possibility.
And if the man you came forward to, let me rephrase, if you didn't come forward for Alex, he could choose to fire you, right?
Objection, speculation, Your Honor.
I'll ask you again. So if he didn't come forward for Alex, he could just choose to fire you, right?
It's possible.
So now I want to talk a little bit more about your story. You said that you arrived to Alex's house at 7:30, right?
Correct.
And that's when you struck Peggy with a fireplace stick.
That's right.
And then you called Alex, right?
Yes.
He came right away, right? And he told you to leave, right?
Correct.
He told you not to tell anyone, right? And that's what you did, right? But you did come forward in April, right? So let's talk more about why you came forward in April. You said you received a note from Alex, right?
Yes.
And you have that note in front of you, correct?
I do.
So let's walk through this note a little bit. This note has 3 numbered sections, right?
Yes.
The first, number 1 on this list says to say specifically that you were the one who stopped Peggy's fire, right?
Yes.
And it says to specifically say that Alex wasn't there that night, right?
Yes.
It also says to specifically say he told you to leave and not tell anyone, right? That's exactly the story you told, correct?
Right.
But there's one detail you mentioned that's not on this list, right?
Sure.
Talk about a burglary code, right?
Yes.
So if you could tell us that burglary code, we would know you're not just deciding facts on this note, right?
Objection, speculation, Your Honor.
Fresh, re-ask that question.
Yes, Your Honor. So this note says nothing about a burglary code, right?
Correct.
So it is a detail that you were provided from Alex, right?
Correct.
But you can't tell us that burglary code, right? You mentioned your direct it's because you can't remember, right?
That's right.
You use this code for 6 months, right? You use this code multiple times a week for 6 months, right?
Sure.
Now you just can't remember it, correct? Now, let's go back to the note. The very last line of substance says, you must help me, right? It's underlined, correct? And then it says, this will have serious consequences if you don't come through them, right? So let's walk through what those consequences could be. Talked about the possibility of not having a relationship with Alex, right?
Possibility.
Talked about the possibility of losing your job. And you know that there's a risk that if you didn't come forward, Alex could go to prison, right? And then you wouldn't be able to see Alex, right? You wouldn't want him to go to prison, right?
I can't speak to that.
You can't say whether or not you want him to go to prison.
I'm just saying I guess I was told to tell the truth. That's all.
I'm not asking you to lie. I'm just asking you, you don't want Alex to go to prison, right? But by coming forward, there's a risk that you might go to prison instead, right?
Objection, speculation, Your Honor.
I'll ask my question again. By coming forward, you're aware that there's a risk you're going to go to prison instead.
There's a risk.
Your Honor, permission to constructively approach. I intend to go into a topic that we discussed in motion in limine, not directly her diagnosis of colon cancer, but the fact that she has a year to live. And I like to clarify the status of that based on the website.
Again, Your Honor, we would object on speculation to the diagnosis and there's no expert here to testify to that diagnosis.
I'm gonna allow that. I'm gonna overrule your objection.
Yes, sir. So, Ms. Mulligan, I apologize. This is insensitive, but you were recently diagnosed with COVID, right?
Sure, yes.
You were told that you have a month to live, or a year to live, correct?
Yes.
So if you were sent to prison, you would spend more than a year there, right?
Possibly, yes.
You gotta, I pass the lens.
Redirect.
Briefly, Your Honor, receive a blood.
You've already been asked for this witness, so that's all.
This letter, Alex, for you, does it tell you to tell the truth? It does. Are you telling the truth? I am. You tell the truth to the government? I did. Were you ever made aware of consequences by telling the truth? No. Never contact you? No. No further questions. May this witness step down.
Maybe some cross.
So, Ms. Mulligan, you just said you were never made aware of consequences of coming forward, right?
The government.
But you talked to Alex about consequences, right?
No, I didn't speak to Alex.
So it's your testimony today that you didn't talk to Alex about the risk of you being charged with murder.
I apologize. Yes, there's a possibility of the risk of murder, yes.
And he told you that it would be justifiable homicide, right?
Yes.
So you were aware that there's risks associated with murder.
Yes, we phrase it like that.
Thank you, and I pass the witness.
May this witness step down. Yes.
All right, next witness, please.
Your Honor, the defense calls Alex Hamilton to the stand. Should I use the well, Your Honor?
Yes.
Mr. Hamilton, please introduce yourself to me.
Luckily, my name is Alex Hamilton. Professionally, I work as a criminal defense.
In your work, have you gone up against the government agency?
You know, that's the name of the game. I'm always up against the enemy.
Have you been successful against the government?
Absolutely.
Do you know what you're being accused of today?
Charging me with first degree and second degree murder, sir.
And I just want to ask you, did you kill this man?
No, I didn't.
You know who did?
I do.
Who is that?
It was Liz Mulligan.
Now, I want to talk about how you know it was Liz Mulligan. What happened January 29th was the first thing that happened.
So I can go ahead and take that from the beginning and kind of explain the chronological order.
Yeah, what was the first thing that triggered your involvement in the facts?
So to preface, I'm a big baseball fan, so I was at a baseball game watching one of my favorite teams. Then I received a phone call from Liz Mulligan.
And can you describe how did Liz sound? Did she sound like?
Hysterical, stressed, obviously a high tense situation.
And what did she say? Your Honor, this is just a excited utterance. We've established that this is hysterical, stressed, like something just happened. So just leave that.
Are you saying it's an exception to the hearsay rule? Yes.
There is no foundation laid for the time that Liz did the killing. discrepancy and therefore not following the letter of exception.
That's subject to cross-examination overruled.
I'll re-ask the question. What did Liz say on the phone call?
That she was already at my house. While she was there, another woman had walked in. There was an altercation between them. Eventually got violent. She believed that the woman, other woman, was Peggy Schuyler. She believed that Peggy Schuyler was reaching into her purse for a gun. And to defend herself, she grabbed a fireplace broken steel one with wood pointed on spikes at the end of it, struck her in the head. And as she touched and killed her.
After she told you, what did you do next?
My first instinct was to kind of diffuse the situation, have her try and calm her down. I told her to go into the kitchen, get some water, calm down, and I would be on my way.
Did you go home after that?
I did.
What happened once you arrived at your house?
So that's when I walked through the door, entered the living room, and I kind of see what's going on around me. I see my carpet. Peggy Schuyler is unconscious on the ground. There's blood. There's that metal fire poker. Peggy's purse is next to her as well. I walked up to Peggy to feel her back for a pulse, to see if she's still breathing. There's no pulse. She was dead.
And just to clarify for the jury, did Liz tell you why she struck Peggy?
She did. There was an altercation between the two women. Peggy Schuyler, from his perspective, was reaching in her purse before he got.
So after you confirmed that Peggy was dead, what did you do next?
Well, I kind of looked first before I did anything. So I kind of looked around, just evaluate the scene. I found a automatic pistol in Peggy Schuyler's purse. At that point, I gathered up the purse, the gun, the poker, and Peggy's body, and rolled it up in the carpet, tied it with some twine. And at that point, I had to put this together.
And after you rolled up the body into the list,
So, just went home. I called my sister, Phil Hamilton, to come over and help me get rid of the body.
did your sister agree?
Well, she did, but only after I offered her $25,000 to help me with it.
Oh, so you had to offer her money so she could help you? And after she agreed, what happened next?
So in the meantime, between her coming over to my house, I took the weapons themselves, drove that to a dumpster, and disposed of that. When I came back, that is when my sister arrived on the scene.
And when your sister,
First and foremost, explain what happened. After that, I asked her to help me load the body into the car, into her car. I asked her to drive it to her boat on the marina and get rid of it.
and did you hear your sister testify today?
Sure did.
Did you hear her when she said she couldn't have carried that body by herself?
I mean, I'm not the most physically gifted or in shape person out there, I can tell you, but I think that that's really preposterous that she said she can't.
And what about the rest of your sister's statements? Was she telling the truth when she was testifying?
No, she was not.
And the government has accused you of lying to the detective. Did you lie to the detective?
I did at first.
And why did you lie?
There's no evidence
Answer. So. Really, for two main reasons. I mean, the scenario itself, I'm in a panic state of mind. But also consider the circumstances. I'm a defense lawyer. I have a pretty successful career. I walk in, there's a dead body of one of my girlfriends on my carpet with one of my fireplaces next to her. It's really an awful look. I didn't think anyone would believe me.
Are you telling the truth there?
Look, I won't say that I haven't lied to try and protect myself in my career, but I would never perjure myself.
Mr. Hamilton. You are tasked with
Yes,
you know the law.
say so.
We can both agree that on January 29th, 2016, you broke the law.
Can't agree to that.
Now, I want to take you to your relationships. At this time, you are dating two women.
Correct.
One of them is Liz Mulligan, and the other is Peggy Schuyler.
Correct.
And these are secret relationships.
Correct.
And this was not public,
It was not.
and none of your friends or family knew about these relationships.
That's correct.
Now, taking you to January 29th of 2016, you received a call from Liz.
That is correct.
And upon this call, you learned, according to you, that Liz Mulligan struck Peggy Schuyler.
Yes.
You didn't call police.
No.
And you didn't do this because you were protecting Liz.
And myself.
And you didn't want the bad PR.
Pretty awful look. Yes.
And when you got into your home, you had Liz leave.
Yes, I did.
And you rolled Peggy's body.
Yes,
Tied it with twine.
I did.
And then you called Phil,
Yes.
dispose of the murder weapon.
Yes. While Phil is on the way there.
So when Phil gets there, there is no murder weapon.
There is not a murder weapon.
And you did not tell anyone until police about what type of tool or the disposal.
Correct. Do you think anyone would believe me?
And then you convinced Phil to help you dispose of the body.
Once I offered Phil $25,000 to do so, yes.
Sure. Let's get to that. You also offered and gave him money for his boat parts.
Yes.
Your Honor, may I approach? I am handing you with what was previously admitted as Exhibit C. This is the check that you wrote to Phil.
Yes.
And you remembered to give him this money,
I did remember to give him this one.
but you did not remember to give him the $25,000 that you used to convince him to dispose of the body?
I hadn't given it to him at that point.
And you heard Phil's testimony and he doesn't recall you offering him $25,000.
Phil doesn't recall a lot of things.
So, no.
That's right.
And you also heard throughout this trial the height and weight of the child.
Yes.
And you also heard, and I guess I corroborated, that you had to help Phil get the dead body into his car.
I wouldn't say I had to, I just did.
But you did help.
Yes.
But to your knowledge, you expected him to carry the dead body by himself.
Sounds like a Great question for Phil. I mean, I wasn't there.
No, I'm asking you. You expected Phil to carry the dead body by himself to the boat.
Yes,
Now, until you spoke with police, you never told anyone how Peggy died.
that's correct.
You never told anyone that it was Peggy. You believe so? Like in Liz Mulligan, no one knew that Peggy had died.
At that point.
Now, you've been here for this trial.
Yes, ma'am.
So you know that on March 1st, that is when Phil spoke with police.
That is when Phil spoke with police.
You were arrested over a month later.
That is correct.
But you also heard how Phil was able to tell police that it was Peggy in that apartment.
Yes, I believe Phil did that after it was offered.
That didn't quite answer my question. You heard Phil be able to tell police that it was Peggy in that room.
Again, yes.
You also heard that Phil was able to tell police the murder weapon was used.
He did say that.
You also heard Phil tell the courtroom today that it was you who told him this information.
After he accepted a deal with the state, yes.
That's not quite my question. So yes, Phil was able to recall what you told him that night.
Phil has a different understanding of what happened.
Different understanding.
Quite a vastly different understanding, I would point out.
But again, we're here, and you heard Phil be able to recollect what you told him in that house.
Yes, but Phil's understanding of what I told him is not what actually happened.
So yes.
Well, no, because the way the question is phrased is that it implies that I agreed with what Phil said. Phil did not tell the truth.
That's again not my question. I'm asking you, you were here whenever you heard Phil be able to give me those details. Who was in that rug and how that person was killed.
I apologize. I can just very clarify what I mean.
No,
I was here. I heard what Phil said. I'm just saying that what Phil said is not the truth.
Right, that's not my question. I'm asking you if you were here when Phil was able to who was in the rug.
Objection to the question asked and answered. My witness has said he was here, heard that testimony about 10 times.
Not the right objection. There is an objection.
Compound,
Nope, not yet.
cumulative.
Not yet. It might be argumentative.
Argumentative.
Right.
And so you were arrested on April 5th, 2016.
Yes.
And then you told police the events that you followed.
Yes.
And since then, you have promised to marry Liz Mulligan.
Yes.
But you also want reconciliation with your wife.
Sure hope so.
And you've also offered Liz Mulligan a job.
Yes.
And when you were arrested in jail, you wrote her a letter asking her to come forward.
Yes.
Your Honor, may I approach?
Yes.
I'm handing you what has been previously admitted, Exhibit D. And this is what you gave Liz Mulligan.
Looks like it.
And in this letter, it contains the facts of the murder. Or your version of facts.
Yes, ma'am. It does contain the facts of the murder.
Your version.
That's up for a jury to decide.
The version that you have testified to today is in this letter.
Yes.
And you heard Liz's testimony.
Oh, yes, I did.
And this is what she testified to.
Seems to be what she testified to as well.
And it was only until after
discuss it. Sent her this letter, and she came forward.
That sounds right. That's right.
Any other questions?
No redirect, Your Honor.
Anything further from the defense?
No further witnesses from the defense. I asked that this witness be able to step down, and then I asked for a brief 5-minute recess before we proceed to closing arguments.
Right.
That one, accessories. I like this one.
They made this objection. Whenever that happened. Shouldn't have done it, should have objected. Same thing, there was a dilemma. You shouldn't have got that, shouldn't have lifted it. But we should have objected. I don't know. Trying to remember. My students run at there. School is here. No damage. First witness. She took both of them. It's your own. It's funny because students over the years, and so I can't. Because it's the last semester, this semester, 2 semesters. She was in. Yeah, my trial. She took trial semester after, which means she had to be in. Yeah, this fall. I know that she would in my last demo class. Or let's bring it to bigger. Sure. These two. Understand? Because he was trying to get her to admit that he called something. He said it. He actually gave it. She was trying to let his counsel know what to object to. He kept saying, she recalled it. Because that's what her question was. So I circled it, recall. She just needed to say what she said, or say the following. She wanted to throw in the argument. She recalled that. Replying, and she recalled something. Very the argument. That's why I was arguing.
I also have a problem with argument.
But he kept trying, he was telling me, he said, I'm not going to admit that she recalled it. That's what she said, but she, so he was trying to get objection. And, so, yeah, we have objections. Why?
Objections are easy.
Right,
Or when you're
yes.
sitting. You're at the table.
Yeah, you want to try it. Super noble. We'll get started in about 2 minutes. Okay. Okay. Does the state wish to obey a closing argument?
Yes, Your Honor, we also asked to save an additional time for voting and also.
We do what? Okay, all right, so what would you like?
10 minutes.
Okay, well, there's a rule. Okay, what I'm saying is that there's 10 minutes is what the overall, you have 10 minutes to complete, correct?
Yes.
Okay, so how much would you like to reserve for your rebuttal? Is that right?
Sorry, what was that?
That time is 10 minutes, right?
Yes.
3 minutes.
3? And no, you will get a 3-minute warning. Okay, and you'll get a 3-minute warning. You may proceed.
May I leave about the law, Your Honor?
And you can use move about the well as well, but.
Secrets don't sing.
Alex Hamilton sure did try. This is a man with 2 girlfriends, both who assume this relationship is very serious. One who was even pregnant. But this was a problem for Alex. One, because he is a public figure who ran for state office and local government. His overall goal, reconciliation with his wife. And so, January 29th, 2016, Peggy Schuyler was murdered. She was murdered by a fireplace stoker. Her body rolled into a carpet, tied with twine. Alex calls and lists his brother. He calls him and asks for his help. comes. He tells Phil, this is Peggy, murdered her, the fire stoker. Remember, this fire stoker is gone. These are the words of Alex and what he told Phil. Then the two of them carry this body into his car. They get onto Phil's boat. It's corroborated by the blood found on the boat that matched Peggy's, the DNA prints, console of that boat, flashlight. Alex then dumps that body. Using an anchor or chain, he remembers to pay that money back to Phil, because that's what they talked about. But the $25,000 that you heard Alex say that's what he had to use to elicit help, didn't pay it. Oh, and also Phil didn't call that because that was never discussed. And the most important part, Phil goes to police over a month before Alex's arrest. Phil is able to recall and describe who was in that room, how that person died. Information he could have only gotten if Alex told him, because you heard Alex. None of his family knew about the relationship with Peggy. No one. You heard Alex. He didn't tell anyone about the murder until speaking with police. Phil knew. Alex told him. Now let's talk about Alex's arrest. Alex wrote a letter. The woman he is promised to marry. He's given her a job. And in this letter, he lists out 1, 2, and 3. Everything that he needed her to say so that he could point the finger at her. He didn't expect Phil to turn on. But he did expect Liz to come up with a story. He told her when the murder happened, how the murder happened, the time the murder happened. He told her, when I arrived home, she was already dead. You did it. And then he tells her, you're not going to tell anybody about this. You must help me. Underlined. The last line is, this will have serious consequences if you don't come through for me.
3 minutes.
With all of this, he knows she only has less than a year to live. That will take care of problem number 2. Its ultimate goal. We have the burden of proof in this case, as the state. We are to meet every single element of this murder. We know that we have done this today. And so when you go into the back of the jury deliberation room, you will return a verdict.
See, Joey. First words that the government said today is secrets don't seek. But what does is the evidence that they need to prove this case. The evidence that they did not even look for. At the beginning of this trial, my co-counsel Bashar, he told you that this case was about guesswork. It's not about police work. About lack of evidence. We've seen all of that today. Before I go into the recap of today's case, I want to remind you, ladies and gentlemen, the government has the burden of proof. They have the highest legal burden. That means they have to prove every element beyond a reasonable doubt. That means if there's a hesitation in your mind, that Mr. Hamilton is not guilty. That means if there's unanswered questions, Mr. Hamilton is not guilty. That means if there's an alternative explanation, Mr. Hamilton is still not guilty. And as the judge read jury charges for you for our closing arguments, there's something included in the packet that I want to highlight. In your packet, it says a reasonable doubt to the guilt of the defendant may arise from evidence, lack of evidence, or conflict of evidence. We have all three of those today. First, starting with the detective. The detective came here today. He told you he did a thorough investigation. Ladies and gentlemen, he didn't even look for a body. That is sometimes important. He didn't look for a weapon. That is sometimes important in a murder case. He didn't interview any other suspects. He came on the stand today, ladies and gentlemen. He told you there was no reason to interview Liz. Liz Mulligan confessed to the murder, and the government didn't bat an eye to interview her. They couldn't question her. That is not good police work, ladies and gentlemen. That is guesswork. That is a reasonable doubt. These are unanswered questions the government failed to answer. The detective also tried to tell you today that it's 2016 and there's no cameras. Ladies and gentlemen, that is a lack of evidence. They couldn't bother to come in here and provide any camera footage. They couldn't bother to look for camera footage because this was guesswork. The detective also told you that GPS data is sometimes important in murder cases. Ladies and gentlemen, this is the highest charge in our legal system. And it is sometimes important. Is it sometimes to be thorough in your investigation? This is guesswork. Now, the government's key witness, or star witness, Phil Hamilton, his sister, they came to the stand today. They told you that they did cocaine an hour before they were called. They tried to tell you this didn't affect them. Ladies and gentlemen, they smoked cocaine. They're in prison for cocaine. They told you on the stand that they won't come out. They don't like it. It sucks. They're facing 15 years minimum, $500,000 fine. This witness has everything to gain. She told him what the government wants to hear. Like this witness came up here, she couldn't even remember what they told the detective. This is a coked out sister. Took a plea deal, made up facts, wants to get out of prison. This is not a credible witness. This is the government's star witness. This is a reasonable doubt. When you go to Liz Mulligan, she came out to the stand today. She confessed. She told you that she killed Peggy Schuyler. She was never even interviewed. The government did not care enough. That is not a good investigation. And Peggy Schuyler, she deserves more than that. She deserves a thorough investigation and good police work. She doesn't deserve guesswork. We have to hold the government to a higher standard than just turning a blind eye and somebody who literally confesses to murder. When you come to Alex Hamilton, I told you on the stand. Yes, he has lied to police. Yes, he can it. You may not agree with his lifestyle, his choices. But that does not make him a murderer. That does not mean he killed Peggy Schuyler. The government never proved that. Each witness, there was the lack of evidence, there was a conflict of evidence, and the evidence showed otherwise. Ladies and gentlemen, as a defense in this case, this is my last chance to speak. Because the government bears the burden of proof, they will get one more chance to come here and speak to you. They might tell you to use your common sense. That's not what the instructions tell you. The instructions tell you to use the evidence. Evidence shows this was guesswork. this is not a good investigation, and there is reasonable doubt with each and every witness, every unanswered fact, everything the government failed to do. Government might come up here and they might tell you, Mr. Hamilton's a liar. That does not mean Alex Hamilton killed Peggy Schuyler. You don't have to like him to realize the government failed to meet their burden. They did not do good police work. But there is a reasonable doubt throughout this case. There's many. They might tell you to use your human experience. Ladies and gentlemen, you must use the evidence, the lack of evidence, the conflict in evidence. When you go back to deliberate, ladies and gentlemen, see this form. There's only one answer to the lack of evidence to support that justice demands.
3 minutes.
Find Mr. Hamilton not guilty.
Rebuttal?
You must use the evidence. I agree. Let's talk about what that evidence is. Evidence, the physical evidence you have been brought, and the testimony from the witness stand. What does that tell you? We know Alex was placed on the scene of his home. We know that he was murdered there. We can place Alex in the boat with DNA evidence. Lack of evidence? Because it was destroyed by a man who was tasked with upholding the law. He told you that. He also told you that he broke the law. Right. And then they brought in Liz Mulligan. She was able to tell you exactly what Alex told you. However, listen out. Instructions. As the state, we have the burden of proof. That is to meet every single element beyond a reasonable doubt. Today, we have done that. So when you get your jury form, and take it back to deliberate, you will mark guilty.
Why don't y'all give us some time? And we'll call you back in. So, there.
Okay.
That's a different to be at 3. If we can. Speedy. Sorry. Oh, for sure. Oh, man.
That means verdict.
You guys watch that show?
You guys know about Hot Mitch?
No.
I'm aging myself. Never heard of that one.
The new show you just discovered or what?
It's 3 judges that talk, or they hear a small claims case and then they go back and deliberate.
I don't usually watch lawyer shows of any kind.
You need to turn it off. I like
it.
We're up to 3.
3.
You're right. You're right.
All right. Okay. Y'all, I think everybody here has heard the lecture about y'all don't take criticism well. Okay, because there's a filter that comes up. So I'm just gonna tell you who won. So that you won't be sitting here worrying about it. Oh gosh, I lost because of this, or I won because of that. And then we were gonna go through, kind of give you some pointers. One of the things we wanted to tell you up front, and I know I'm burying the lead a little bit here, was that I don't want you to think that what we collectively want to do is that we want to try to give you things to improve upon and different ways to think about things as opposed to, man, you did a great job here. Because you did a great job. You all did extremely well. You're here in the finals for a very good reason, and it's very clear. And so you're not going to get a lot of accolades and attaboys and pat on the back because of what happened here. We're going to try to help you improve as you go forward. But the winner is prosecution. Still there. And just so that we all are clear about that it was extremely close, very, very close. I mean, I can tell you what my numbers were. It was very close, but it was unanimous. So that's all you always want to know, whether you won 10-2, 11-1, or whatever. And you are the outstanding advocate for this. Thanks for that.
Yeah, let's go.
Okay. What we're gonna do is gonna give you a brief kind of overview of some things that we think could be improved upon. And I'm gonna start, then we're gonna go back and we'll probably rotate on who goes first, because the problem is I've done this enough. I've done this so many times, particularly in the NETA courses, where I don't want people to rob what I want to say. So we rotate the things so that we can, because we're only going to give you, as in our class, one critique per person, not a bunch, because you won't listen to the second or third one anyway. So prosecution opening statement. You commented. You committed mistrial right off the bat, okay? Because you commented about what the witness is going to say. And one of the witnesses is the defendant. And the defendant never has to testify. They can take the Fifth Amendment. If there was some kind of agreement beforehand, you needed to address that with the court and said, we understand that we've agreed, and so we are not commenting on the defendant's waiving of his Fifth Amendment rights. We're not putting that in jeopardy, because as soon as, if there hadn't been no agreement, as soon as you said that, boom, that's an automatic mistrial, because the defendant does not have to testify. Now, wasn't 100% certain of that, but I confirmed it before, because I wrote it down. I said, I can't. So I would just say there are the ways to a way around it. Said, well, the defendant's position is going to be as follows. And that's not what the defendant is going to say, because you can't talk about you can talk about the defendant's credibility in certain ways if there are other statements and things about nature that are being admitted, but you cannot talk about what they're going to say from the stand. Okay.
So this is hard for me because I like to give, positive feedback. I don't like being the bad guy. But for prosecution, for the opening, I think it was unanimous for us that you didn't necessarily lay out the facts right away, right? You went right into who was going to testify about what, but there was, and correct me if I'm wrong, but there was little about the date and time and what happened. And then you go into, you'll hear from this witness, right? And so we were kind of looking for that.
My feedback is pretty much the same, so I don't want to just repeat it, but what they both said. So whenever you are wanting to talk about the defendants, what they're going to say, first, you don't want to commit to the jury that the defendant is going to testify, because even if there is that agreement, what if he doesn't testify? What if he changes his mind? What if he sees how you guys treated the other witnesses and he backs out, right? So it's good to just say, I anticipate that you're going to hear that they're going to pin on somebody else, or whatever you think the defendant is going to say, you can say it, but not that he's going to be the one to bring it out. I did like your opening, I think a little more than them too, but they did make really good points, and they were right. Just make sure it's a very clear and concise storyline to continue to engage the jury and make sure that everything comes out naturally.
Again, these were good, and so we're picking a bit, but I want to. One of the things that caught me in the on your opening was you basically lowered the burden of proof because you made a comment, and I'll say this: words are important, and you basically said something along the lines of if you're not going to believe that, and therefore because if you don't believe, and you use the term believe, and the reality is that the jury could believe that he did it. But if they don't present the burden of proof, you must acquit. So it's not a matter of what they believe, because you have dramatically lowered the burden when you commit to them not believing something. Because, and basically the focus is going to be on the specific burden of proof. I didn't, they have to prove beyond a reasonable doubt. Pound that in immediately. You dilute that when you talk about what the jury is going to believe or not. Because again, like I said, they could believe that he committed it, but they didn't. But if they don't provide it beyond a reasonable doubt, then they don't have to. You understand what I'm saying here? Does it make sense?
So I can tell that you were a little nervous at first, but toward the end, you kind of got your groove there a bit. But I think kind of like with your storyline also, I mean, it already kind of sounded like the theory in the case was no body, no murder, right? And like no weapon, no this, no that. I think I would have been more like, this is what the state or the government just doesn't have, and this is why they can never meet their burden beyond a reasonable doubt. I really didn't have a lot of feedback for our opening.
Yeah, I didn't really have a lot on the opening either. Just piggybacking off of what they said, I did write down that I think you said, and I know you were nervous, that killed Alex. I wrote that down, and obviously Alex is a defendant, so I was just that just stood out to me because you had the wrong person being killed in your opening. But that was all.
So city.
Okay. Can I?
Oh, go ahead.
I was gonna say, as far as the pretrial motions, I just wanted to say, we skipped that. I thought both of you guys were really good. I can't help but to put that out there.
Oh, that's fine. You can say that. But we don't want to, it's like, like, yeah, rah, rah, rah. That's what we're trying to do.
I think you guys really got them flustered a little bit. I will say that you were headed towards saying the right terminology when we talked about Liz and her saying that she only had a year to live. And when they asked that question about why the prejudicial versus probative and why it is how it is, credibility is always relevant, right? It's always important. And so I was looking for you to say that, and I think you were going there, but you just didn't find the right word, right?
Want to do the first one?
Yes, so we had Jay Lawrence, that was you, Sydney. So for you, my main thing for you was just objections. Just make sure whenever there is an objection, when it's overruled and your witness can't answer what you were doing, you were just moving on. You weren't, like, we didn't hear what that answer would have been. So just make sure when there's an objection and it's overruled, re-ask your question and then make sure your witness just answers, because every time there was an objection and it was overruled, you just automatically moved on. And then one thing also, so there was a pre-agreement with these, well, I'll just do that one. I'll let y'all, sorry.
You can say it if we don't get it.
I will. Yeah.
So we were just, we talked about this, in the back. So I know this is a problem, right? And there were certain stipulated facts, but you didn't necessarily have to read the stipulated facts because you had your witness testify to them and then you read them. So we didn't quite understand why you did that. And I don't know if that was something you guys discussed or, but you don't have to do that.
You can incorporate them in the questions.
Yes, you can incorporate them in the questions, right?
Okay, they challenged the quality of your testimony, of the investigation. And what I would have liked to have done is seen you go a whole lot more into the qualifications of your investigator so that she is not questioned about, in other words, you said a few things. I'm going to give you an example. I hate to, y'all heard me talk about my dog bite case. Okay, remember the dog bite case. All right. And if you remember that there was a big question as whether the guy that did the dog bite would do what he was doing. A completely unrelated story about training to sniff emeralds from the cocaine mine is what convinced the jury that this witness knew exactly what he was doing regarding training dogs. And I keep going back to that, and I know I use that so much, but that's so true in this case because you have someone and they're doing all this stuff. They didn't do this, they didn't do this, they're doing this. Well, the reality is that there's a big reason behind some of those things that were not there. And if you were to go ahead and talk to her and let her talk about how long she's been there, did she do any investigating when she was in the military? I mean, on and on and on there. If you build her up, then they have a less opportunity to tear them down by this stuff. So y'all don't know anything about the dog bite case. So they have heard about it. They've heard about it ad nauseum. So, but because anyway.
So we're gonna do the cross now of Will. I'm sorry. The detective by Will, yes. So I will say that I saw you a few times getting ready to object and you kind of, I feel like you talked yourself out of it, but always object, right? The worst that the judge is gonna say is that it's sustained or overruled. You know what I mean? So just be confident in yourself. When you did object to the receipt, I thought you were gonna say no foundation was laid, right? Because a lot of the times when you guys went to introduce a couple of the evidence, a couple of the exhibits, I was like, did they lay a foundation, right? And so just remember to do that. And I know evidence is hard. I still struggle with it, but I just wanted to give you that point.
So I think that you could have just went a little further with the detective here. One thing I have is like you were asking like, I don't remember what the question was, but my note is that, yeah, we didn't know because you didn't investigate, right? And that was your whole cross. You don't know, you didn't investigate, you didn't have a weapon, you didn't find it. I feel like this was good, but I feel like it could have been just more. Like you don't know how she died because you were never able to find her body. You knew that she was at the bottom of the Gulf of Mexico. I didn't send divers out there to at least go locate her. And y'all knew that the weapon, that he disposed of a weapon, you didn't ask where and you didn't try and find it. Like there were so many things that you could have, you started out very strong and it was just that little more that I was looking for. So just make sure like you're breaking up every single thing. So the goal is to discredit her, right? Like she didn't do a good job in the investigation. She didn't go to any other suspects. Phil could have been the murderer, right? Like, well, we don't know. She didn't investigate that. So just make sure every time you're going like step by steps and making a list like that, you're just spreading her at every chance you get why she didn't do X, Y, and Z. What are her qualifications to even investigate this, you know?
Phil was never, the detective never spoke to Phil.
They did speak to Phil and got like a very basic story that was objected in.
Yeah.
That was after, I can find the exact date, but it was
So what I'm getting at is that specifics as opposed to there was no other suspects. I don't like that question because how can there be a suspect unless there's something else done in advance to identify the suspect? Witnesses is the question. You didn't talk to the other way. You didn't talk to all the witnesses. Wait a second. We now know someone that has confessed to the murder. What have you done? I mean, because I believe that there was a whole lot of cross-examination regarding what could have been done regarding, if you have someone that has, you know, that's my understanding is now there's someone else that has confessed. Right. Yeah, you're still prosecuting this, that kind of thing. So I think that it is fair game to go into, if you're gonna go through, they don't have this, they don't have this, they don't have this. Well, you have something very specific and you were talking about investigating, you know, you didn't ask any suspects. Well, wait a second. It's only a suspect. Yeah, but somebody confessed. And I think that needed to be juxtaposed. Now, if there's something in the problem that says you can't do that, is there?
just in her deposition, they never testified that the detective knew about Liz confessing. So it was kind of like this gray area about what he knew about.
Okay, may I? I'm gonna show you this letter. You haven't seen this letter?
Okay.
You don't know what this is? I mean, you'd agree with me, would you not? That there's someone that has actually confessed to this crime. And you're not here to evaluate that at all, because that was not part of your investigation at all. I mean, you continue to investigate this case up until right before trial, can't you? I mean, you don't just stop at a certain time now, do you? Yeah. All right, then the next person is, so, you want anybody ready? to talk about
Yeah, I can talk about Phil.
I can't read my hand.
So that's you, Alyssa, right? So I have more good things, and I was like, well, good, but I do think that the directive Phil was good. I think that you did a good point to rebut different defense arguments that you did. But you just didn't get all the bad facts out first. I don't really remember hearing a lot of things about Phil being arrested, right? So that's a bad fact that you want to get out ahead of time.
You just took mine.
I'm sorry, we didn't talk about that one first. So we know that he was high, or he at least smoked an hour before, right? So that's something that you would want to talk about, because they're going to talk about that all day long, right? Well, I thought that they would have. So just make sure that you're getting all the bad things out. I did think that it was good that you repeated the question after an objection. You waited for that person. Sorry.
I like that.
Well, I'm gonna say, I'm sorry. What's your name?
Sarah.
And what's your name? Mary. You, well, all you guys did really good with being witnesses, but I just wanted to say, don't beat yourself up about, okay? I think you did a really good job at getting him riled up, right? And so I just want to give that feedback to you, okay? So don't, it happens.
And that it happens in real life, like exactly on both ends. The witness being difficult to opposing counsel, and opposing counsel trying to pin you down to, you know, the answer. So that I see that all the time.
Aside from what Erica said, I just really have good feedback for you. I thought you answered. I'm sorry, you asked great controlled questions. You had great responses to the objection. I think your name is Bishara.
Yes.
Yes. I think you have a great presence when you cross-exam. I mean, like you're tough. I think that you did a good job attempting the impeachment. From what I hear, you guys haven't necessarily learned that yet. I don't know.
I mean, I know how to impeach. I just was getting, because I was trying to do a recall, like they didn't recall. I was going to impeach.
You mixed, what you did was you mixed refresh recollection with impeachment. And by the way, that's what most lawyers would do it, to tell you the truth, but,
So what I was going to say is when you came back, so it was leading up to a great impeachment and then you went to get the paper to do it and then you came back and you asked her a third time and then it switched to refresh and recollection. And I think it would have hit more if you impeached her versus giving her the chance to, say she didn't remember.
okay. This is gonna be more toward closing, but it's important here. There was a major fact that y'all didn't ask in the direct that you then used in closing argument that y'all should have caught and objected to. Because the $25,000 was never mentioned in your direct examination. So is that what you, that's something, there was a second thing too, that was not, we're gonna get to that in closing. It was mentioned in his, but it was not mentioned in Phil's, because you argued Phil doesn't remember the 25,000. That was never mentioned in Phil's. At least when I heard it the first time, I said, well, because you were, well, Phil said this. Well, I didn't hear him say that. And I went and asked him, did they hear him say no? It's in your notes, I'm sure. All right, good. All right, so I would just say, be very, very careful. On cross, I think that I would have played up more of his criminal background. I mean, hell, he committed a crime with his brother. Has he been charged for that? I mean, what he did was obstruction of justice and conspiracy. I mean, there's about 100 crimes he committed by helping his brother, but he hadn't been charged for those. He hadn't been charged. I mean, in other words, I think there was a lot to cross-examine him and all on that I think he kind of left on the table a bit. And, it doesn't take long. And anything that you can do to, question his credibility, then I say go for it. And so that's what I would have, but I agree that from the refreshing recollection, you were kind of halfway, you did half and half. All right.
For cross, I'm not big on objections, just because on this side, it's hard to do it over there. Right here, I'm listening to them and listening to what could have been objected. So when she's not answering your question and you're trying to really get her to answer, especially like the plea deal, right? Like that's non-responsive, right? All day long. Like she's not answering your question, but you keep asking the same one. And then at that point, they object to ask and answer it. She answered it, just not the way that we know she should have answered it, right? So just make sure you're objecting to the non-responsive and showing the bias there. Of course, Bill is getting, whether it's a plea deal or an agreement by the government to recommend a lighter sentence, right? Like make sure you show that. So if you testify, whether it's the truth or not, you sitting right here is going to get you a lighter sentence later. And that is why you're here. Not to do the right thing, not because of your conscience, because you want to get out of jail. And you really did start doing that at first. Like, jail's not a good place to be. You have to go to the bathroom and bring people. You have to eat this, crappy jail food. Like, you really started that. And then you did end it, you ended that aspect a little lighter than I probably would have done or seen. I probably would have been like, yeah, so the reason why you're here is because you're tired of doing all of that. You do want to get out and you want that lighter sentence and that, that fine. You want all that to go away. Like if you just would have pounded a little bit harder on that, but you did do a good job walking up those steps.
Okay, then next one is
This.
this.
Really quick on halftime motions, we don't have a lot there because he overruled it, but you were right about the jurisdiction. I've definitely seen a directed verdict in real life. If you don't prove that it happened in that county, then you are done. Obviously, we weren't going to do that here, but that was right all day long.
Yeah, she reached out to me and I could go home early and watch the football game, but I don't think that really meets our purpose. But yeah, be careful. All right,
No, Liz, correct.
um,
I mean,
I'm trying to figure, yeah, go ahead, Kelsey.
Okay, I have one.
Yeah, go ahead.
I think there was a question asked of Liz, was she ever a suspect? I think that-
Yes.
Yeah, I didn't like that question because I thought it was speculative, but, I could be wrong. Maybe you could have asked it in a different way, but I was just like, ooh, ask that, cause how would she know, right?
I have a factual question. Does Liz and Peggy know each other?
Yes.
Did they knew each other before this event?
Well, it depends on who you ask.
Okay, and so therefore,
They knew of each other.
okay. I just was, okay, I felt like there needed to be a bit more background. Yeah, one of the problems with the mock trial is that there's some assumptions made because y'all have lived with it, and that even the judges will have the problem in front of you. I purposefully don't go into depth when I'm doing this because I'm the jury. So I'm gonna have the same questions the jury has. That makes sense? All right, so when I'm looking, I understood the bigger points, but the small points that make the credibility leap that you want, I'm asking those questions because for example, there was a casual mention that she was pregnant at the time, okay? What happened? I don't know. Y'all know. I don't know. Was she pregnant when she got the letter? No, she wasn't. We know that now. I didn't know that. I asked those questions. So I'm thinking if that's your witness, you need to make sure that those are unanswered questions and that they're answered questions. And if they are bad for you, you need to attack it on direct and provide the explanation. But there was just things that I did not, and when you showed the letter, right? What it all it says. Yeah, and I'm violating my own rule, but I'm gonna say it anyway. I didn't know what serious consequences meant, and I think that you needed to address with her what she felt like serious consequences were, because if I was them, I'm about to say, to me, I thought they left a lot on the table with that sentence right there. But I would have just, what did she think this meant? But, and it was just a way of looking at the evidence, I'm suggesting.
So I started off with writing that you were good to get ahead of a bad fact, which would have been that code.
Yeah.
Right, but she didn't remember the code, so then you kind of got ahead of that, which they did a good job rebutting that. But I think another bad fact that you could have gotten ahead of was the length of time that she had to live, and then that's a bad fact that you would normally get ahead of, because they're gonna use that, right? Like, of course she's gonna admit to this crime that she didn't commit, because she only have, at this point, she probably only has like 8 months, right? So I think that's something to just get ahead before they do, because then it just looks like she's just taking the rap. And then I'd probably also get into more of the way that she was feeling at the time, right? Like, she was pregnant when this happened. So she sees this lady who is sleeping with her boyfriend, and she vice versa. And she's going into her purse with a gun. What is she thinking at that time? She's pregnant. She has a baby in her belly. She needs to protect herself, her child, and she just did this. So I would get into her state of mind and why she chose to call Alex and not the police. Why did she listen to him? And just different things. And like, why is she coming forward right now? She didn't come forward before because she was still pregnant. She was still scared. She didn't want to be in jail and pregnant. So that's why she waited. Now she's realizing that she has to do the right thing and come forward. So I would have just gotten all that out before they did, and then just making her look very sympathetic. And at that point, she's the victim now, right? Because she was about to die.
Yeah.
So if you can get the jury to believe that, then that's how, you know, the right walks.
Oh, you guys said everything. I don't have anything new.
Okay. Cross-examination. There's a lot to go through here. You did a good job, I thought. I would suggest though that, I asked this question. I viewed that letter as nothing but a threat. And that by the person you're trying to convict of murder, threat by someone who's been charged with murder, threat by someone whose people said the word, and now if he's saying to this person, there's going to be serious consequences if you don't do what I say. And I think I would have played that up a whole lot more, because that, to me, this is a witness from jail providing the testimony that they want, which you did a good job of, and then saying, and oh, by the way, if you don't, the same thing that happened to my last girlfriend is going to happen to you. That's why I read that letter.
Well, for cross though, I do have that, your cross was really good. And then, well, your objections were good and then your responses were good. I have, good things. One thing I do want to go back to the detective. So anytime you're doing like a problem, like almost every line is important. One thing that didn't come out was that the detective had this whole, anniversary dinner and saw the defendant and Peggy, right? That is something that I would have asked, because one thing that she said, which should have been objected to, was all he did was lie, 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 lie. Well, what's another lie? The lie was he said that he never met, knew, slept with Peggy, when we know that's a lie because the detective saw them having dinner together. So that was one thing I forgot to talk about before. That's all I'm just saying.
I was just gonna say this was pretty hard for me. I mean, I thought that like Erica said, this was a really great witness to cross, direct, all of that by both sides. I think that you were hitting the points, so you were just like, you know, so this didn't happen and this didn't happen, and I was just waiting for that last little thing to like really stick it to them. And I think you were leading up to that, but just, you know, put the nail in the coffin.
Or there's not enough time to do an effective direct and or cross of Alex Hamilton. Just not enough time. You could, you know, direct examination, there are so many holes that you've got to fill, and it just, but you don't have time. You have 10 minutes and there's no way you can get it all in. This is a witness that would take literal, if you were going to put him on, highly question that you ever would, but if you're going to put him on, you're looking at a couple of days worth of testimony. Because you've got to explain so many different things, or at least a couple of hours, if not a day, because there's so many things that need to be explained that you need to get out in order to get it there. And you also want him to be, talk the jury to see him a bunch, and if he's doing good, then that means that, you know, he's witnesses, the direct examination of witnesses, the star. But I felt like, from a standpoint of what I felt that I could, from a constructive, there were things that I felt like you should get out in front of. So, and one of them would be, and I'll give you one of them. I don't understand maybe it's in the problem. Y'all help me out here, because neither one of you hit it. So I don't understand why I didn't buy the explanation why he didn't go to the police. And I guess I would have, I just didn't really I don't get that part of the problem. And if I'm sitting here as a jury listening to it, and you can say, you know, hit it, but I didn't feel like that you know, he's a criminal defense lawyer. He knows exactly what he needs to do to prevail. And he also knows the ramifications. I mean, his reputation is one thing, but going to jail for murder is another. And he's basically committing all kinds of crimes on top of that when he had the ability to just say, and I want on cross-examination, that's been my number one thing. Wait a second, time out, hold on. You're telling me you're a criminal defense lawyer. To get out of this, all you had to do was call the police right then and there as soon as you got there. And we're over, we're done. None of this has mattered. All this other, that's all made up a bunch of stuff. That's my comment on cross. My comment on direct, the same thing. I think that needed to address that more thoroughly. And on cross, you need to exploit that more thoroughly.
I think definitely on the direct, this defendant who's juggling practically 3 women, like that should have definitely come out, right? Like it's already, and maybe this is for closing also, like there's a special place in hell for my client for these 3 women, but he's not guilty of murder, whether it's first or second, right? So I think that's another bad fact to get out. Like you guys heard that he got 1 woman pregnant while he's trying to, either divorce or get back with his wife. And then now there's this other woman who either I killed, she killed, but I helped, dispose of the body. So that's something that I would definitely talk about. The jury just already does not like he they could have said not guilty of murder. Maybe he didn't do it, but like they don't like him because he has women in his back pocket, and that's what they know. Maybe there's more. So that's just something that I definitely would have talked about more.
Can you guys tell she's an ADA? So I was gonna say that I love this whole witness. Are you a theater major? Like, I love the direct, the cross, like the acting, witness, everything. But I will say that, and I think we're gonna talk more about this with the closing, but there was a lot, especially in this setup, where there were a lot of facts that were beyond, so in cross, there was a lot of facts brought up that were beyond the scope of direct, right? And you guys didn't object to it. You guys know what I mean when I say that?
Yes.
Okay. So that's all that I would say about that.
I mean, we're not really allowed to do that objection.
I think he did say that, actually, now that he says that, yeah.
No, don't say what objection you're not allowed to do.
Beyond the
So we
scope
talked a lot about that, and I guess they weren't
of
able to.
director cross exam, yeah.
And then speculation sounds weird, some of those objections, like, oh, you should do that, but like.
What was the purpose? I would like to know from a standpoint, what was the purpose? If you, something that's in the problem and you don't bring it up in your direct examination, why should you be able to address it in closing arguments? And I don't know, is that something that this is specific to this problem? Because I think that's what everybody just agreed to that. I didn't know that.
So are we saying that they can't create facts?
That's
And
what
then
it
say,
is.
you can't create
Yeah.
facts.
You can't object, you can't object to outside the scope of the problem. So yeah, you can't create them, you can't object if people create them. You kind of have to come up with another reason.
So I wasn't saying that they created the fact. There was facts that were in the problem that were brought up on cross, right? The questions that were asked on cross about facts that were in the problem, but no one brought it out on direct.
I'm gonna explain the objection. Because there's an objection, you kept going, right? And your witness was trying to help you. He gave it to you. He gave you the real reason why. Because what her question was he told you what, or he tried to, the argument at his point was not what he said, but she kept throwing in what he recalled seeing. Well, he was never going to admit that he recalled seeing it because his position is that it never happened. Her question was a classic, when did you stop beating your wife type question. And that's why it was argumentative, because if he agreed with her, then he was having to agree that he recalled what he saw. And he even said that, he said, I'm not gonna agree to this question because it's not what he saw. And finally you corrected it and said what he said he saw. Or what he, whatever it was, but the point being is that he was never going to agree, and that's why I was arguing that. And that's why I was objecting. And so your instincts were spot on. There was something wrong with that question. All right. And so I appreciate you making it, and that's why I wanted to make it at that point in time let you know exactly what the reasons were. But, anyway, that's, on the cross. I didn't know he was married. I didn't recognize he was married until the cross, which I felt should have been addressed a lot sooner in the presentation of the case. It was mentioned, but it's a big deal. I mean, he's cheating on his wife. He's got cheating on his girlfriend. I mean, she said it a moment ago. So I would have just, I'd have maybe harped on that a little bit more you know, and maybe throw in the sidebar, what does your wife think about all this? You know, you don't have to, sometimes best objections, best questions are not answered. So.
I just wanna clarify, I wanna go back to what I said. Are we saying that you guys couldn't object to assuming facts not in evidence? Is that what you're saying? Cause I think that's different from beyond the scope of the record.
Beyond the record shall not be entertained as an objection.
Right.
So maybe that means beyond the scope.
No.
I didn't get that.
So beyond the record, I think is like if you guys make up facts, because this is a problem, right? So if you make up facts, but if someone doesn't testify about it in direct, then technically you're not supposed to ask about it on cross.
Or you're not supposed to referencing in your closing argument.
Yeah, or in your closing argument.
For that, for direct, and when you're allowed to cross line, you don't have that limitation. But for the closing, you do, so it has to be brought out in the trial to bring it up in closing. But for cross, it's not limited to direct.
Okay. Just for this problem though, because in real life.
Yes.
Okay.
Well, and the reason why is that, and the reason why that's that way in that specific element is because you don't want to hurt yourself and your presentation simply because you don't have the ability to call for the witnesses. You're limited to these two, so that's why it's that way. But you still on the closing argument portion, it has to be discussed somewhere in the trial before you bring it up. And that's where I felt like there was some leeway taken. There were two things we found.
Before we get to closing, just really quick, City, your cross, Alex, right? Your first couple questions, like I thought I knew exactly what was going so good. You know the law, right? You broke the law, right? And then you kind of like moved on. You came back, but it would have been good for you to be like, you know the law because you're a defense attorney. You broke the law even though you're a defense attorney, and you broke the law when you agreed to help Liz. And that's what he's saying, right? He helped Liz. You wrapped the body yourself. You twined it up yourself. You called your brother to help you dispose of the body. So I would have hit on every point of that night where he broke the law. Up until right here, he had been breaking the law the whole time. He never said anything. He told Liz to not talk about it at all. You know, so I would have definitely like just completely broke that down line by line of every step that he took that night by breaking the law.
All right, so closing, I did not see any, and correct me if I'm wrong, any first degree murder in this case, premeditation, right? And that was one of the charges. I didn't see it at all. And you guys didn't mention it in your closing as well, like they failed to meet their burden. So that's the biggest, I know I don't want to repeat anything, so that was the biggest thing that I saw. It would have been not guilty if I was on the jury.
I agree, and we talked about that. And it probably would have been a not guilty verdict for that reason. I'm gonna just go back to the both of you asked for a verdict, which is appropriate, but it was general. And what I'm gonna suggest, and this is for both, read the question that you want them to answer and then put in the answer right after and give them the answer to it. Because I want you to put it here. The question number one, your answer is guilty or yes, or whatever it might be, doesn't, because this is all about persuasion. By you reading the question, you can emphasize the parts of the question with your verb, with your words and your tone as to what is the important portions of it. And if you need any explanation, you can provide the explanation, because let me tell you what's going to happen. You're going to read that to the jury, And while you're reading it, you're gonna almost be thinking about how they're hearing this. And sometimes you're gonna come up with that one bit or two bits of good information and say like, and here's why, here's why the answer is yes, because look at this, and this is what we proved. And I think that I think both of you need to spend a little more time, and you had time. Both of you need to spend a little more time outlining specifically what the question is, and then specifically the answer. So, and then in the real world, you'll have it up on the screen and all that kind of stuff, and they can read it. You can read along with me, whatever it might be. But I think both of you probably could have done a better job of identifying the specific question, and that goes along with you didn't hear. It's kind of a summary, but you didn't hear what was the first degree versus second degree murder, and I don't do criminal work, so I don't know how you alternatively ask that question. But I know that that's part of it.
So yes, so as far as like your closing, so as a defense attorney, I just feel for this problem, there would have been a guilty regardless, right? It's not always, oh, you want the not guilty, it's what would be the best outcome here. Because even if Alex is found guilty of second degree murder, that range of punishment is from 5 to life. So guess what? He's guilty of second degree murder, sentenced to 5 years. So I would have been like, here's a charge. The state did not prove their burden of first degree murder. This was not premeditated whatsoever. Even if you believe that Alex did commit this crime, even though Liz came to testify and that she did it, this was not planned. This was a heat of passion. This was, they were arguing and he just did it. It's not premeditated. If you believe that he did this and find him guilty of second degree murder, but you should find him not guilty because, he didn't do this, it was Liz. Definitely walk them through the jury trial. Not all the time will jury have the visual. It's really up to the prosecutor or defense to make that visual for the jury. So if you want them to read along and stay with you in that moment, then yes, you would put it up, whether it's on the overhead or on a PowerPoint. And yeah, go to that question. The state did not prove that he did this because he wasn't there when it happened. He was at that ball game that he talked about. Liz did this because she was mad and she was so scared, like walk through every which way. The state did not prove this case. And then same on this side, how did you prove it? We know we proved it because Alex was afraid that this girl was going to come forward and expose their relationship and expose that she's pregnant with this child and expose that there is yet another woman involved. And then one thing that I don't really remember hearing is that he was trying to reconcile with his wife, right? And that did come up in closing argument. So that was one thing that could have been objected to, speculation, facts, and evidence, because he testified that he was getting back together with his wife, right? Like all we know is that there's these two competing women, this one guy, one killed the other, or Alex killed her because, she was coming out. So just go through every step of how we know that he committed this. I did like that you did tie in opening argument, right? Like secret seat, like that. I do think that was really good, and of course we've seen it in trial for real. So I do think that was good.
Overall, I think you guys did really good. I'm from New York, so I just moved down here, but I'm from New York, so I'm licensed in New York. And when I was talking to them, and I'm like, what is this? I passed the witness. I've never heard that before, right? We don't say that there. Or can I freely move about cabin? I think you guys kept saying. Well, we go up to a podium.
Actually, this is the conversation we had. All of you stood.
Yes.
Fine.
I've just always done that for mock trial.
What's that?
I've just always done that for mock trials.
But why? I mean, because of my problem?
Yeah, I guess.
So this is federal.
Okay.
So maybe at next time a podium should be present.
We see that federal court, this was throwing me off. if this was a state court, which this is not, but if it was state court, in Texas, you said, and you have to ask to move around, okay? Federal court, Texas, you stand behind the podium, you don't move around. And so, it's hard, and so what I think that if you can move around, then I think all of you need to use it more effectively. You go back and forth, I talk in a triangle when I'm in court, I try to do the triangle. I mean, I purposely move in certain areas. I don't get to stand up very often because you question most of the time from our seated position. But in opening statement, closing arguments, or things of that nature, you can move around, and I try to talk but that's just, I talk in a triangle. But so I'm just curious because all of y'all did stand, and if, I did not know if that was, and the reason is being, I guess, federal. Yes. But, I just, does Judge Williams, does she ask you to stand all the time?
Pretty much all the time.
Interesting.
I would definitely move with the purpose. Like, Sydney, whenever you were crossing, I think it was Alex, you did approach him a little bit, and all of you did as well. Like, whenever you're crossing, you use your hand movements, went closer to, witness stand. So I would just say make those movements with your body. If you're just standing still, it's like it kind of seems stone. And sometimes I start listening. I have to make myself come back when you're just standing still. So just make sure you're just moving with a purpose, whether it's your witness or not.
How many rounds did y'all have?
5.
4 or 5. And y'all do both sides the whole time, or were you always one side or the other?
We mainly did prosecution. This is our second time doing defense.
So who do you guys think would have had the stronger case?
From the problem standpoint,
Just if you guys are law students, right? Had the stronger case.
Defense, I think the facts are pretty bad for the state.
I think it's defense too.
Just a reasonable doubt. I think there's so many other questions. So they can even go out and search for a body.
I think prosecution. With the facts that we have, I think specifically,
That means it's a good problem.
I think he
it's
did.
a problem, but.
You would never want this guy to testify. He sucks.
The only
Well,
reason
I
I
mean-
felt like prosecution had the better case is because both Alex and Liz say that they told nobody. They said nothing about everything that happened. They never, he never told Phil how she was killed. He just said that she was killed and he didn't do it. But somehow Phil knows everything. He knows the murder weapon. He knows that they took his book. He knows literally everything that happened. So that's the only reason why I thought it was prosecution, because you catch Alex in this lie. But how does Phil know if you told nobody?
That reminds me of something. So we talked about this too. We thought prosecution should have flipped the witnesses.
Yeah.
Right, and did the detective second.
So
Phil.
yes.
Because I want to give you an example. There was a specific bit of evidence that I excluded.
Mhm.
And one of the reasons I excluded it is it was hearsay. I could have in my opinion, could have been done on relevancy too. I'd have taken either one of them because I had no idea why you needed it. But I heard that but then I heard afterwards, then I understood why you needed it. I don't remember exactly what that was, and I'm
It
thinking,
was the receipt for the rug.
yeah.
We didn't know. Why do you need, this would just be any receipt. Why is
Right.
the rug relevant, right?
All of a sudden, once the other witness came across, then all the things that this police officer was saying, all of them made complete sense. But they didn't because it's kind of one of those things, you have to make sure the jury's receiving all of this, and they need to receive it in the way that's in the best light and the easiest for them to comprehend and put together. And so that's why, because I wrote down here, I said I would switch. I wrote down, should have, I basically say you should have switched. And I thought you'd have been better off somewhere.
You guys think, what year are you guys?
Yes.
Oh, so graduation.
They were all two else.
Yeah. If y'all were when, take my class. That was which semester? Yeah. Yeah. Okay. And
Have you guys taken it?
we're in it right now. Yeah,
Back
and
to
she's
pick on you
taking every
guys on
class she's taken every class I teach, so. I mean,
Well, I helped teach Nita.
And so, yeah, yeah, but, because I couldn't remember when, I knew it wasn't right now. And I knew they are, so that's why, because when, I know you know how to impeach, but impeachment is in 2 weeks.
Well, being 2 L's against 3 L's, I mean, you couldn't tell. You guys did
I
good.
mean, you really- I mean, I kind of knew. It's my job, okay, well, not really my job, it's my hobby. But I thought that this is a very factual intensive problem. I don't think you had enough time in a mock trial. I don't think this is a good problem. And the reason I don't think it's a good problem is I think there is way too many facts. This needs to be not a half-day scenario. If you want to take and try this all day long, you want to have a one-day trial. I think this is a very good problem for that, because then you could have a lot more time with each individual witness. Right now, you just don't have enough time. I just think that that's one of the things when we evaluate what problems are to use in a mock trial or in a classroom setting or a NETA setting, is that you need to make sure there's ample time to go through. This would be a great NETA problem, because if you did a NETA class, it would be basically a 3-day intense where you're using the same problem all 3 days. This would be a great problem for that. There's a lot to go into. But I think in this setting, and it doesn't mean that it's not a good problem. I think it is. I think it allows you to showcase showcase what you can do, but it's hard. But there's just so much to go through in this particular problem. It's hard. I wouldn't recommend against using it. I just recommend understanding that there's so much that you can do that a lot of times when we do critiques, it has to be really big picture critiques regarding the facts, because the little stuff doesn't make any sense because it's not fair to you. So something that I may think is important that's tiny, I tell my adjuncts when they did their critiques, be careful about critiquing on the subject matter. Because if you critique on the subject matter, you are really delving into the way you would try it versus the way someone else would try it. And you want to make sure you're teaching them about techniques versus the specifics. And so, and that's one of the problems with this problem. I think it's going to be, it lends itself to some questions that maybe you just didn't have enough time to do.
Yeah, it was a little bit complicated. I had to read it like 5 times before I understood like who says what's this each person's story is.
And you just switch both sides.
Yeah.
That's the hard part.
And so they've heard it, but you all haven't. But there's a lecture that we actually give when you switch to the last problem, which is going to be your final trial problem. That there's a formula of what you need to do to start to get ready for it. And that is literally read it the first time with nothing, just go all the way through. Second time you can make a few notes, and the third time you read it with notes and make notes to yourself. If you in that way, that's the kind of the sign it works to make sure that now you've included it, because when you read it the first time, you really are not going to comprehend everything. It's the second time before you truly get a better picture, and the third time when you do your work. And then after that, then you dissect it, go through it, and all that kind of stuff. But it's hard. I can imagine it. It's really hard, but I thought y'all did a very good job.
Thank you. Thanks for your time.
I really did. I enjoyed this. I haven't done this in a while.
I've never done this.
I do it all the time in New York,
And
so.
as you guys know, I don't ever sit in on your classes. I just finished, and I got to do on the depot, but I don't get to do on the trial. I don't get to do this, so I enjoy doing it.
I have a question for since you're from New York. I'm wondering what are some more stylistic differences between, I guess, from what you have seen in Texas. I'm just asking because there's actually some competitions coming up in New York judges. So like, what are some things,
They're gonna be confused just like me. I think that was the biggest. If I can think right now, I would have to. I mean, I'll be happy to exchange information with you so that I can really think about it and give you some tips. But I think that, and then sitting down too. I mean, when they told me that, I was like, sitting down? That is so awkward. Sitting, asking questions, and we would never do that in any court. And like I said, the podium, I think pretty much everything else. There might be some, I don't know how involved the actual competition is when it comes to writing. Because we were discussing, me and Erica was talking about Texas law versus New York law when it comes to writing briefs and stuff. And just certain language we use that Texas doesn't use. Like, I don't know if you guys, upon information and belief, you use that language?
You want to write a brief.
In your pleadings?
I've never said that out loud.
Well, I'm saying in your, they said they don't use it here, right? And so in New York, we use it all the time.
What about the past the witness? You don't say no further questions.
We say no further questions regardless of whether, well, we say that at the end. I will say once the judge will say any other questions or do you have any further questions? And I'll say no, Your Honor, the prosecution rests, or I'll say no further questions. They said that they only say that when you're completely done with the witness.
Yeah.
We say that when we're done questioning.
So even if you go back for redirect, like if you're done with your direct, but you plan on doing redirect, you'll still say no further questions?
Yeah, we'll say no further questions, and then the judge will say, defense, your witness, or something like that, right? We don't even say your witness half the time. Some people do, but most times we don't. So that was different to hear. Not even just the language, but you guys actually saying it, so.
I've never heard of anything other than passive witness.
Come to New York, no.
Passive witness, they go, what does
I was
that
like,
mean?
passive witness, what does that mean? I was so confused.
Can we get a picture of, with all the competitors and then the teams individually?
I was gonna ask, can I
And the
get a picture
judges,
with them?
yeah. No, everyone and then the teams individually.
Smile. Shit.
Oh, you were great.
I'll see you tomorrow night.
Thanks.
Yes. See you tomorrow night.